right, good morning, everyone. I want to welcome you all to the Medical Board of California's August quarterly board meeting. I'd like to just do a few quick announcements, administrative items before we get into the board meeting. I want to ask us all to please turn our mobile devices to silent. For those members of the public who are here in person or are viewing online, you will notice that board members are accessing their laptops, phones, and other devices during the meeting. They're using these devices to access board meeting materials that are in electronic format. If you are a member of the media and you require assistance or information, please see Emily Ross raising her hand there in the back. This is an official business meeting of the Medical Board of California.
Mr. Colby, this is the conference operator. We're not getting any audio in the conference.
Is that on our end, or is that something for me? Okay, I'll keep going. This is an official business meeting of the Medical Board of California. As such, disruptions of the board's business will not be tolerated. Government Code Section 11126.5 does allow a board to remove people who willfully interrupt a meeting and to clear the room or virtual space if order cannot be restored by removing or muting the disruptive people. We do have a designated time on today's agenda for public comments on items not on the agenda, and we will ask for public comments on all agenda items. It is the board's intent to ask for public comments prior to the board taking action on any agenda item, but if for some reason I forget to ask for your public comment on an agenda item and you wish to speak on that item, please just raise your hand or come forward and you will be recognized. The meeting is being webcast and is also available via teleconference. Individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by a moderator who will be facilitating the teleconferencing process. For those members of the public that are participating via teleconference, please do wait until the moderator has introduced you before you make your comments. To request to make a comment during the public comment period, press *1. You will hear a tone indicating that you are in the queue for comment. If you change your mind and you do not wish to make a comment, press *2. Assistance will be available throughout the teleconference meeting, and to request a specialist, please press *0. When providing public comments, please do conclude your comments within 3 minutes or less. After the allotted time for speaking has lapsed, the speaker will be placed back on mute, and only one public comment per agenda item will be allowed per individual. During agenda item 2, which is public comments on items not on the agenda, the board has limited the total public comment period for individuals to 40 minutes. Therefore, after 40 minutes, I may decline to accept further comments. During public comment on any other agenda item, 20 minutes will be allowed for the comment period. And after 20 minutes, I may decline to accept further comments. Each person will be limited to 3 minutes per agenda item, but this time may be reduced depending on the number of people who wish to speak so that more people may be heard. Today's meeting will be run according to the Open Meeting Act as required by law, and we plan to end today by 5 p.m. I would now like to officially call this meeting of the Medical Board of California to order at 9:08 a.m. Ms. Lopez, if you would please call the roll.
Dr. Balat? Here. Mr. Brooks?
Here.
Dr. Hawkins?
Here.
Dr. Hauser?
Here.
Ms. Zhang? Mr. Watkins? Ms. Lubiano? Dr. Mahmood?
Yes.
Mr. Lee? Dr. Tsai? Here. Dr. Thorpe?
Here.
Madam President Lawson?
Here, thank you. We have a quorum. I would like to remind the members and the public that we will be taking a roll call vote on each action item. I also, before we get into the agenda, want to announce that agenda item 12, which is officer elections, will be held at the end of today's meeting versus at the end of the day tomorrow. And that the reason for that change is because we're concerned about having a quorum present, and that is an action item, and a quorum is required for a vote. So we will be taking that agenda item as the very last order of business today, unless there are any concerns with that approach. All right. Okay, we are going to move on to agenda item 2, which is public comments on items not on the agenda. Before I do call for those public comments, I would like to ask individuals making comments to please not discuss pending complaints, pending licensing applications, or pending disciplinary actions that may come before this board for a decision. Such discussions are considered ex parte communications, as they could provide information to our members that is outside of the record in violation of the Administrative Procedure Act. Therefore, such discussions could create a conflict and lead to a board decision being challenged in Superior Court. The board can receive comments regarding the board's processes in general, but it cannot receive comments at this time on specific case circumstances where a decision is still pending. In addition, the board requests that members of the public address the board as a whole and not individual members or members of our staff. And please do be aware that public comment during this agenda item should provide information to the board members and is not a discussion between the board members and the public. The only action board members can take is to listen to comments and decide whether they would like a future agenda item on the topic. No other action can be taken on the item at this meeting, and though this may seem at times like board members are not being responsive, following these guidelines is critical to ensure the rules of the Open Meeting Act are followed and to avoid compromising the speaker's goals or the board's mission. If you'd like to comment on an agenda item, please do wait until we get to that agenda item. Comments at this time are only for items not on the agenda. Please do limit your comments to 3 minutes or less. We are going to start with public comments here in the room in Bakersfield, and we do have with us this morning 2 very distinguished guests from Bakersfield. I'd like to first invite Mayor Karen Go to come up and address the board. Welcome, Mayor.
Good morning, Madam President, members of the board. Welcome to Bakersfield. I'm Karen Go, G-O-H, Mayor of the City of Bakersfield. Welcome to California's 9th largest city, where we feed and power the world. California, we know, is such a diverse state. Our community, though, provides 70% of our state's oil. We provide more than 50% of renewable energy, and we're #1 in agriculture. Unfortunately, the Central Valley is home to unfortunate statistics. And here in the Central Valley, we are the #1 community in maternal mortality. We're #2 in infant mortality. And so today, we welcome you. Thank you for taking the time to come to our community. You'll hear stories, and we look to you. You'll hear stories from Tracy, Michelle, others who've traveled even farther to implore your board, and we look to you for your wisdom, for your guidance to protect our residents and to protect all Californians. Thank you for this opportunity to have your board here with us, and we look forward to positive outcomes as you're here to join the the 9th largest city in our state. Welcome to Bakersfield, California. Thank you so much.
Mayor Go, thank you for that warm welcome, and we are certainly grateful for the opportunity to be here to learn and to listen and to experience your community. So thank you for having us and for the hospitality of your great community. Next, I would like to invite Dominic Hayden, who is a representative from Senator Shannon Grove's office, to the podium.
Good morning. My name is Dominic Hayden, and I'm here on behalf of Senator Shannon Grove, who represents portions of Kern, Tulare, Fresno, and San Bernardino counties in the state Senate. I'm here to welcome you to Bakersfield and to thank you for providing in-person access to the residents of Bakersfield and to Kern County. We do indeed face many challenges that are common to rural areas in terms of health care, people having access to the providers and specialists that they need in order to get the care to have quality of life. So we're grateful that you're here. I want to welcome you and also thank you as well for the legislative liaison office that the medical board provides to the state offices. We have a great working relationship with the legislative liaisons to be able to assist our constituents by reaching out to the medical board for information. So thank you for that. Welcome, and thank you for allowing me to speak.
Thank you, Mr. Hayden, for the warm welcome as well. Many of us as appointees have had the opportunity to meet with and get to know Senator Grove a little bit through her role on the Senate Rules Committee. So we're grateful for her service and again are really pleased to be here in your community. So please pass along our regards to the Senator. Thank you. Thank you. And now we will move on to public comments. There may be other leaders in the room. I'm not aware of them, but please, if you're interested in making public comments, let's start in the room here. Please come on up.
Thank you so much.
Just use the microphone,
Thank you so much for having this meeting and being open to public comments. My daughter entered Kaiser Permanente for severe gastric distress and orthostatic hypotension. She was not on opioids or benzos as an outpatient. And to try to keep it short, she entered the hospital looking like a beautiful young woman. But in a month and a half, she looked like Auschwitz, 40 pounds of belly edema, her hair fell out, she had a movement disorder. It appeared over this month and a half that no one recognized she was being destroyed but me. This is all reflected in the medical records. I was using her secured email to communicate with them saying, what's happening, she's being destroyed, and I would get answers from doctors that watched the whole downfall that she looked better to them. And she was being bounced around from Kaiser Santa Clara to Kaiser Redwood City to Kaiser San Leandro. And sometime, for no medical purpose I know of, but just moved around. And at some point, her origin story of the healthcare crisis was that she was living, her prior level of function was living in a skilled nursing facility. And she was just being described as a chronic. But prior to this long hospitalization was now being characterized as she's just a chronic who's been had multiple hospitalizations. And so I want to suggest, I would like to request that because she was working before, she was a full-time nanny, she had plenty of friends, she was going out to dinner, going to movies just months before the hospitalization. She should never have been described like that. And the one person in the whole of San Leandro when she was there for 2 months, this just kept getting worse and worse. And I'm just sticking to something that maybe you can do something about. If doctors were to wear body cams like police officers, there would be a record of who this human being was when she entered, and they could never get confused like this. It was every time they moved her around, it was like they'd never seen her before. She'd never left the hospital. And then I'll just stop there with the story. But then she was overdosed. Anyway, she was overdosed to death for whatever reason. I don't know why. She wasn't terminally ill. She had a full code pulse. So she didn't make it out of there. And because what I saw was so horrible, and no one, Kaiser has not even offered a settlement. Not that I want one. This isn't about money. I don't expect to get much. It's a young person that died. But I thought it would be an opportunity for them to learn something from this. But so far they have not. And I'm in a brutal arbitration where I'm being laughed at by the Kaiser lawyer. And the arbitrator, I was wondering why I was being treated so badly. So I looked up the case history of the arbitrator, and he's never once sided with a patient in 20 years. So that's where I'm headed. Now, for whatever reason, he's never seen a case that had any merit, which doesn't make sense to me. That's what I got. But I don't want to see this ever happen to another person again. And if they can't keep track of what a person looked like yesterday, even when they knew them for the last 5 years, some of these people are her normal physicians that watched this. downfall of a beautiful girl. So body cams, then every time a new doctor cycles in a hospital, they would know how this person arrived. The only person who seems to know who she was is an occupational therapist who writes it down, and then one of her hospitalists goes in about 1.5 years after her death and changes the date. So I'm not sure you would even see that record if they gave you the medical records for while she was alive, because there's a lot of weird stuff going in this record. So I'm begging you to please make sure that for some period of time, every patient, there is a record of what they look like, because you can't even look at these videos of what they took her down to. But then she recovers just by stopping all medications. So there's a much bigger story here, but I think a lot of it can be solved with body cams like police officers have to wear, so everyone knows who they're dealing with, because she just became somebody who was futile to them and of no worth to anyone, and that is not true at all. She was only 26 when she died. She entered at 25, had her last birthday in there. So there's a series of photos. I didn't take these. I wasn't trying to immortalize her in this horrible condition, but other people were. So I have a series of the takedown. You can order them by what's in the frame because of the growth of her hair. When her hair started falling out, her sister gave her a buzz cut. And now every video and photograph can be ordered by in the frame. And you can see this person, when she's getting better, they're saying she's eminently dying. And when she's eminently dying, they're saying she looks better to them like this. And all of this is in the records and can be proven. I would like to know, so I can stop looking at this and fighting for whoever else is in those beds. I would like to know this can never happen again. Is there anyone here from Kaiser Permanente who will say, is somebody from Kaiser on this board from Kaiser Permanente that can look at this case and make sure that this never happens again?
Ma'am, we thank you very much for coming and for sharing your story. We are deeply, deeply sorry for your loss.
And
we thank
her
you.
case has come before you and has been investigated by the Nursing Board, the Department of Consumer Affairs, and other entities. So you had the case, it was closed as if nothing happened. And I never got a letter, no one ever responded to me. I called for years, and I never got an answer. But, from the records, I would expect you to think I'm just crazy. But if you look at all the people that loved her, that visited her, and all these photographs of what happened to her, you'll know the story is completely different from what you see on those records. And I'll never allow myself to be in a hospital after that. So thank you.
Thank you for your public comment. I'm sorry, just one second. I'd like to invite you to follow up with our enforcement staff, Ms. Jones, if you could just identify yourself, and so maybe she can take down your name. And
I've been communicating with her.
Great, then you're already in contact. Dr. Thorpe, did you have a comment? Dr. Thorpe would like your name. We didn't catch that for the record.
Lisa DiMartini. And my daughter's name was Angelica Rose Shebold. She has friends that attribute to her that they graduated with their 4-year degree because she tutored them through it, and she was a very valuable person, and you'd never know it by looking at these medical records.
Thank you. Thank you for your public comment and for joining our meeting in person today. Next public commenter, are there others in the room? We've got someone in the back. Please just make your way up, and I would ask you to please try to stick within the 3-minute limit. I'm going to try to afford people the opportunity to tell their stories and share public comments today, but we do have a 3-minute limit, and I need to try to stick to that just for meeting management purposes. Please, welcome.
Good morning, members of the board, members of the media, and public. My name is Denise Johnson. I am from Tracy, and a volunteer with Consumer Watchdog. I would like to thank you for bringing the quarterly board meeting here to Bakersfield. I drove down from Tracy to have the opportunity to meet you face to face, and for you to see the face behind the WebEx screen. So you can see the person who has been fighting on behalf of my son, Richard Johnson. I was disheartened to see Public Citizen's new medical board ranking report of serious physician disciplinary actions where California was ranked 27th in the country. We speak before the board and at sunset reviews and legislative hearings, but it really puts things into perspective of how few of our death complaints are addressed with any form of disciplinary action. This board issued only 0.83 serious disciplinary actions per 1,000 patients per year. This board would have needed to take 138 additional serious disciplinary actions per year to match Michigan's disciplinary action. Those 138 serious disciplinary actions would have meant accountability and justice for my son Richard, Larsenia's husband James, Alka's sister Shilpa, Tracy's daughter Demi, Xavier's son Malachi, Naomi's sister Sabrina, Susan's near-death experience, and I could go on and on. These serious disciplinary actions are actions taken to not only give accountability to the Californians that die, but to also protect the rest of us that are still here. Thank you.
Thank you very much for joining us today. Are there others in the room who wish to make public comment? Please just make your way up.
Sorry, I'm emotional already. Good morning. I am Monique Kimes, and I'm from Bakersfield, and I'm a volunteer with Consumer Watchdog. I would like to thank you for bringing the quarterly meeting here to Bakersfield. I've participated at many of your meetings for the past few years. Sorry. And sometimes felt like you were not listening to us, but bringing your board meeting to our city has meant everything to us. Sorry. And our efforts to save other lives here in the Central Valley and across California. My reason for taking so many days off of work to participate in your meetings is a beautiful 5-pound baby boy. My grandson, Malachi De Leon. It was heartbreaking to watch my grandson fight for his life and see doctors try to enter him into studies instead of airlifting him immediately to a hospital that had the resources to provide him the care that he needed when he needed it. Knowing that Malachi's mother was inpatient in a hospital with no care plan and no diagnosis offered to her by a repeat offender doctor, and later watching Malachi's mother and my unborn grandson be rushed out of her OB's office and not given the life-saving care they needed, put my grandson in that situation. Again, thank you for bringing the meeting to Bakersfield. I look forward to the next couple of days and finding a way to work together to increase transparency and to begin the hard work of stopping some of these extremely negligent acts from continuing to take other babies' lives. Thank you.
Thank you for joining us and for sharing those comments. Next speaker.
Hi, everyone. Good morning. I am Tracy Dominguez, and I am from Bakersfield, and I am a volunteer with Consumer Watchdog. I would like to thank you for taking the time for bringing the board meeting to the Central Valley. I am hopeful that this meeting will be a starting point for working together to bring the change that and many of the follow advocates have been asking for. There are some great doctors that care for their patients here in Bakersfield, and there are the congenitals, the bad ones, that are shedding a bad light on the medical field. The best way we can address this issue for all doctors and their patients and the public is working out a plan to address the repeat offender doctors. We can do this. We just need the will to do it to save lives. Thank you, guys. I appreciate you coming to Bakersfield, and I believe Bakersfield will be the start of a change for California patients. And thank you.
Thank you, and thanks for joining us here in person. Next public comment.
Good morning. My name is Naomi Sweat. I live in San Diego, but my hometown is Bakersfield, and I appreciate you guys bringing the quarterly board meeting here to Bakersfield. I'm happy to meet you in person so that you can see the person advocating in honor of my little sister, Sabrina De La Rosa. I joined this team because I wanted to make sure that my sister's life and death was included in the narrative and advocacy to curb the maternal morality crisis in Central Valley. The doctor that was treating my sister Sabrina during her pregnancy was already on probation for harming other women for sexual misconduct. He also had been charged with 28 felony counts for fraud, grand theft, and conspiracy to commit a crime. To top it off, you guys recently filed another accusation against him for fraud that he is committing by buying drug testing machines and charging Medi-Cal for drug tests that his patients don't even know that he is administrating to them. None of these actions or recent accusation has anything to do with Sabrina's death, but he's still out there practicing. My little sister's death was one of the 138 serious disciplinary actions that should have taken place. The other women that were harmed by him and lived should have been at least 2 other serious disciplinary actions, and those disciplinary actions should have been strong enough to have taken him out of practice, which would have saved my sister's life. These reports need to be reviewed, discussed, and we need to come up with policies and actions to put a stop to repeat offenders of the doctors. Thank you.
Thank you for joining us, for sharing your story.
Good morning.
Good morning.
I'm Chaplain Reverend Ruth Summers Tweedle, a.k.a. the food people, all the rest of that, because we give away meals. I would really like to say that we are supposed to forgive those who despitefully use us, but we definitely need to stand up against the wrong and stand for the right. Okay, there needs to be a staffing change. There needs to be more staff, and I'm recommending that Genevieve Sinati lead a team of about 10 people that works with the Department of Justice, because it should not take 6 months for a case to get to you. The problematic portion of that is that when it gets to you, like in our instance, we have been paying refrigeration. It started off at $125 a day. Then it went down, they dropped it for us after 2 months to $480 a week at the mortuary. But now they're saying, since the body has been out now over a year waiting for the review to take place, they're saying they're going to send him to the morgue and he may be cremated. Okay, so if you guys would if DNA needs to be taken, if one autopsy says one thing, the other autopsy says something else, especially in reference to the cause of death, and then body parts are lost, like the brain, so on and so forth, it would make a lot of sense to have the DNA check to see, and especially since some of the body parts look like they were kept in the desert and others look like they were kept in a swamp or the ocean based upon the difference in weight between the autopsies. Okay, there's one other thing that I would bring out to you is And we really need your help by Wednesday because they're taking them to the morgue at the mortuary, and we've sent you letters in reference to that. And then also, we need to find out what is going on with these charges of payments to people in assisted living and places like that, based upon the fact that they get all kinds of different people who are saying that they're their physicians, but they're not related to, they've never seen the people before, and the assisted living places are giving the people $25 out of their retirement money in order to live for the month, and they can't even go to a ball game or even own a cell phone. It's ridiculous that our seniors, I'm 70, turning 71 this year. Thank God I got used to all my limbs except for what that doctor did to my teeth. But in the meantime, we need to be at the point where we treat our seniors better. So that was more staff, and I'm recommending Genevieve, because she was really kind with us, but she couldn't do any more than she could do, to work with the DOJ so the thing doesn't take 6 months to get to you. And then along with that, the other thing that we asked for is that DNA be done immediately, because that's another $23,000 that we're being asked for, and we've already spent over $30 on refrigeration. And so if you guys could do the DNA, it would be a little bit less. And then the other thing about it is help the seniors out that are in assisted living. It's insane that they're not being able to. I mean, one guy said, I can't even buy a pack of cigarettes. Not that he needed them. But at any rate, you guys will be blessed and prosper and realize that all people are important, not just the ones with our titles behind our names. Everybody is important. It's different trees and flowers and ants and elephants. Everybody's important. God said good and very good. He created each one of us. Everyone is wonderful and fabulous in here. If everybody was just alike, it would be like looking at a painted wall or a blank sky, day or night. So just know that we're all wonderful, so let's take care of each other. You guys be blessed and prosper. And again, Chaplain Reverend Ruth Summers Tweedle, and please do something about Ravel Tweedle so that he doesn't get burnt in the morgue. God bless everyone. Thank you.
Thank you.
Thank you for joining us.
Hello, medical board members. My name is Juliana Avila, and I'm a licensed marriage and family therapist in Kern County. I am a certified perinatal mental health therapist, and I have dedicated, I don't know why I'm getting emotional, I'm sorry. I have dedicated the last 2 years of my practice working with the perinatal population. I want to share information regarding birth trauma and perinatal mental health. Birth trauma occurs when a mother's birth experience is perceived as deeply disturbing, and according to the National Institute of Health, it occurs to 45% of mothers. Birth trauma can lead to post-traumatic stress disorder, which occurs in 9% of mothers. I experienced birth trauma during my delivery due to obstetric violence, in which I was coerced, dismissed, disrespected, touched without consent, and pressured to agree to interventions I didn't want. I am lucky to be alive and have my daughter be alive. Although doctors cannot control the unpredictability of medical emergencies during labor and delivery, they should never be the cause of birth trauma or the reason trauma was worsened. Doctors will always hold an authority and power over patients, and patients are encouraged to trust their doctors. Let me tell you this, my experience has made it extremely hard to trust doctors again. I know I am not alone in this, as we have so many family members who have lost their loved ones due to medical negligence. We need trauma-informed providers. We need providers who listen to their patients, who respect their wishes, listen to their concerns, and are held accountable when abusing their power. Doctors need to be patient-centered. not just policy-centered. Mothers need to stop being treated as a chart or a number, but an actual person deserving of proper care. As a therapist, I have the unique perspective of also working with medical providers. And I know there are some really amazing providers. And I see them burnt out as well. And this makes me think this is more of a systemic issue that needs to be addressed. On the topic of perinatal mental health, like many have mentioned before me, we are having a maternal mortality crisis, especially here in Kern County. Our mothers are suffering, which leads to baby suffering, which leads to family suffering. 1 in 5 to 7 mothers experience a perinatal mood and anxiety disorder, and they are not being screened properly. Postpartum Support International states when perinatal mental health disorders are left untreated, they can lead to premature or underweight births, impairment in the parent-child bonding, and learning and behavioral problems later in childhood. They can even raise the risk of maternal mortality. After my traumatic birth, I was quote-unquote screened for my mental health, but never referred or given any resources. I had to seek help myself, and I knew how to do that because I'm a therapist. I cannot imagine the challenges for someone without the knowledge or ability to seek mental health services after a traumatic birth, depression, anxiety, or other mental health disorders. Pregnant mothers should have more routine screening during pregnancy and more than once after birth. They should then be properly referred to appropriate mental health services. I bring this up because pregnant mothers are primarily treated by OBGYNs in the U.S., and unfortunately, only 25 of those impacted by perinatal mental health disorders are treated, and that is not okay. I am also here in support of SB 815 to help give patients who experience maltreatment by doctors get the voice they deserve and keep doctors accountable for their actions and the way they make patients feel. I am also asking doctors in Kern County and in California to be trained in trauma-informed care and engage in more routine screening for perinatal mood and anxiety disorders during and after pregnancy. Thank you for your time.
Thank you for joining us, for sharing your story. Next public commenter, please.
Good morning.
Morning.
I'm Michelle Montserrat Ramos, and I'm with Consumer Watchdog. I want to first welcome you to Bakersfield, and I'd like to thank you for agreeing to bring your meeting here to the Central Valley, and I think in the next 2 days, you'll see that it was a really good decision to bring the meeting to the people. I actually wanted to take the time to introduce myself to new board members, but I see they're not here. And most of you know me and know my story, but in short, I've been coming before this board for 17 years now. And I've did that because, like many of the members of my team here, I submitted a consumer complaint many years ago, and it was closed to the Central Complaint Unit. I decided at that time to come to medical board meetings because although I had done my investigation, I had a complaint that fit into a binder, I had done everything I possibly could think of to write the most effective complaint possible, I really felt that I needed to come here to learn how this board does things. You know, what your rules and procedures are. So I did that. So I really thought at that time I'd spend a few meetings here, get to know the process, file my complaint, and I had no doubt that, of course, it would go to investigation, consider the circumstances behind it. But it didn't. And so, like many of the families that I bring to these meetings today, I was devastated. You know, I say this because, you know, I want you to know how much these families go through, you know, to participate in these meetings. And today there are advocates here for my team that drove down from San Francisco and San Jose and Tracy and Menlo and San Diego because they wanted, it's one thing to be able to participate by WebEx, but it's a completely different experience to sit here before you and for you to hear, you know, what these courageous families have to say and feel. I think you actually feel what they have to say. So I wanted to say that, but I also, since we don't have public comment tomorrow, I just wanted to make a comment that I kind of glanced through the materials. I didn't have a chance to really review them last night, but I know I've had a conversation with a few of you here, and I really hope when we discuss maternal mortality and maternal health tomorrow, I really hope that you take the audience into consideration when we have these discussions tomorrow. It's incredibly important to take that into consideration tomorrow because I really feel this is a step in the right direction, and I really feel that all of us, including the departments, can actually start. It'd be a starting point to make a change and actually attempt to curb the maternal mortality crises, not just here in the Central Valley, but throughout the state. Thank you.
Thank you, Michelle, and thank you for being here in person, too. Are there other, please come on up.
Good morning. My name is Alka Airy, and I'm from San Francisco, and I'm also a volunteer or patient advocate with Consumer Watchdog. I've been dialing into meetings since 2020, and this is my first opportunity to meet with you in person, and I brought a picture of my sister. I lost my older sister to medical negligence, not just at one hospital, but at two. At the age of 43, she went in to the hospital with a stomach ache, which turned out to be an intestinal infection, but that wasn't caught. Instead, she was kept overnight in the hospital, vomiting profusely, and then wheeled into an operating room for an endoscopy, an exploratory endoscopy. And for some reason, the anesthesiologist breached the medical standard of care and didn't intubate her. And she suffered an immediate, massive pulmonary aspiration. It destroyed one lung, and within days, both lungs were shot. She was on ECMO, she was on a ventilator, she was in a medically induced coma for 1 month. And I was with her 15 hours a day until they kicked me out of the ICU. I had to call my parents from India. And my father was a scientist, had a medical degree as well, in addition to a PhD, but was a scientist. And I had to explain to him what happened. And for those of you on the board who are medical doctors, I ask that you put yourself in his shoes, having undergone medical training. How could something like this happen? It was an overt breach of the medical standard of care. But it happens. And by the grace of God and some wonderful doctors in that hospital, she survived. But she was left with 20% diffusing capacity, 30% forced vital capacity, tethered to an oxygen tank. And she was told to live her life. But what life was that? Stuck to an oxygen tank? And then we transferred her care to another hospital, research-oriented, and with a lung transplant program, and we thought she would have the best care possible. We trusted them. I personally wanted to come down to LA. I thought she would get better care there. I had concerns, but no, she convinced me. The team would do their utmost to help her. For 4 years, we went to the doctors. She had pulmonary function tests done quarterly. We saw her primary care physician quarterly. We saw her pulmonologist, who was the head of the department, quarterly. And throughout this time, nobody bothered to look at her heart. She's on supplemental oxygen, 2 to 3 liters, continuous flow. Nobody bothered to look at her heart. And what we found out 6 months before she passed away, she was asked to have an echocardiogram done for the first time, and immediately found to have end-stage right-side heart failure. It was one of the most egregious cases of negligence in this country I thought I'd ever encountered. How could this happen at one of the most preeminent transplant hospitals? She had, oh, by the way, she was being seen by the lung transplant program throughout these 4 years, every year, and yet still nothing. And then when she started asking questions, how could this happen without a heart attack, without any type of acute event? How does a 47-year-old woman who's otherwise healthy come down with end-stage heart failure? And you think at that point, immediate transplant listing. But no, they actually just kicked us out because apparently her questions made them uncomfortable. And it is a bit ironic to have this meeting at this time because to the day tomorrow is when we had the meeting with the transplant team, and they told my sister and I, as her caregiver, that if we ask any more questions about her care, she will not be listed for a lung transplant. No one has ever tried to silence me, my sister, and having to explain this to my father, he didn't understand either. She was eventually listed for a transplant. When we acquiesced, by the way, we said we will stop asking questions. And she was listed. But by then it was too late. And she didn't get the lung transplant that she needed. And I've been coming to these meetings and speaking on behalf of my sister because she's not here today. And what happened to her should never have happened. And I think it's a common theme with all the other families here today. We don't feel heard. And there are some outrageous, egregious mistakes that are happening, and we don't get the attention we deserve. And when we turn to the medical board, nothing. My complaint was dismissed after a few weeks. Nothing. And my sister's negligence case involved a lung transplant program. And through my own research and investigation and work with UNOS, the federal agency that handles transplants, I found some very disturbing details about how my sister's transplant listing occurred and how test results weren't reported accurately, and it impacted her place on the list. I mean, all I know is she should never have died. She should have been given a chance. And I would have loved to have had the opportunity to tell the medical board that with my complaint, and I never got the opportunity. I never got the opportunity to share the records from UNOS. I never got to share the emails. My sister was inadvertently copied on emails with her doctors, and that's how we found out the gist of the mistake. I wasn't able to include any of that, and I would have liked to have the opportunity. And unfortunately, my father was in shock when my sister passed away, and I lost him just a few months ago. And the pain and heartbreak he felt losing his eldest daughter. Having been trained in the medical field to have something like this happen, and you know, a variety of physicians breach the medical standard of care, and there's no justice. It broke his heart. And I just ask for those of you who are physicians on the board to put yourself in his place. If you had lost your oldest child under circumstances when you could see the breach of the standard of care, it can happen to anybody. I mean, I didn't know this injustice existed. I used to represent hospitals and insurance companies as a banker. I had no idea these mistakes happen. And having gotten to know many of the other patient advocates over the years, I'm shocked it continues to happen. And we have to change. We have to do something. And I do want to commend you for coming down to Bakersfield. I think it's remarkable what you're doing in the area of maternal health. And I hope that we'll have your attention in other areas of reform, because we do need change. We do need to help patients in California. We need to do more. Thank you.
Thank you for your public comment, and it is, I'm grateful for the opportunity to have you here in person after hearing from you all these years. Additional public comment in the room? All right, seeing none, we have 10 public commenters on the line, it sounds like. And who's managing that for us? Jacoby, are you managing that for us? Okay, perfect.
To our first caller on the phone, Wendy Connect. You may go ahead.
Thank you. Good morning. I would like to talk to you today about enforcement, specifically the enforcement of Assembly Bill 1278. As many of you know, I was the genesis for this bill. First with my member, Adrian.
Can we just pause for 1 second? Can I ask the public commenter to pause for 1 second? Is there any way to improve that audio? Is that on her end?
It's on her end. If you can go louder or quieter, but
Okay. Just if the public commenter can hear me, it sounds quite muffled. And so if you could speak clearly.
Yeah, I keep getting feedback.
Keep getting feedback. Any recommendations? Oh, because she has the computer up.
I'm just on the phone.
Okay, why don't we go ahead and try that again?
Can you hear me now better? Hello?
Maybe a little bit.
Can you hear? Hello?
One second. Okay, go ahead and try now.
Okay, can you hear me now?
Yeah,
Okay,
why don't we
I'll
just keep
start
going?
over.
Yeah.
I would like to talk to you today about enforcement, specifically the enforcement of Assembly Bill 1278. If you didn't hear my introduction, my name is Wendy Connect. Many of you know that I was the genesis for this bill. I worked with my Assembly member, Adrian Nazarian, on this bill for years. To refresh the board's memory, the bill simply states AB 1278 would require physicians and surgeons to provide a written or electronic notice of the open payments database to a patient at the initial office visit. The bill also requires physicians and surgeons to post an open payments database notice in each location where the licensee practices in an area that is likely to be seen by all individuals who enter the office. Additionally, as of January 1st, 2024, all physicians and surgeons would need to conspicuously post the same open payment database notice on its website. The medical board voted to support this bill. The medical board is also the enforcer of this bill. If the physician does not comply, it is deemed unprofessional conduct. I would like to ask many of you board members if you have ever seen this bill enacted, or if so, enacted properly. I've only seen it in very limited cases, one being my own husband's office. But in general, many or even most doctors and office managers have no idea how to comply and enact this bill properly. Reggie tells me that they have put an article in a newsletter and information in the Q&A. This has not been nearly enough to be effective in getting compliance with the law. Licensees have not received any specifically targeted information on this bill. Additionally, the limited information provided has not been enough. Repetition is key. In discussions about this with Reggie and Tim Kirkmeyer, I have asked and Reggie has agreed that there will be future emails directed to licensees specifically on this bill, with AB 1278 being the only subject, along with suggested sample templates for implementation. This would be the most effective way to help licensees comply with the law. I am personally very frustrated about this lack of communication and the lack of effort to inform doctors about AB 1278. The intent of this bill is to give citizens of California tools to be better informed patients. They need to know how to find out about potentially dangerous doctors with conflicts of interest. Knowledge is power. This would have completely changed my circumstances. I urge the board to follow through with the commitment Reggie has made to inform licensees about the requirements of AB 1278 and assist them by posting sample templates and suggestions to make the law easier for doctors and their office managers to implement. Thank you.
Thank you for your public comment. Can we go to the next commenter on the line?
Our next caller is Annie Wong. You may go ahead.
Hi, everyone. Hi, I'm Dr. Annie Huang, and I'm an emergency resident physician at UCLA. I hope the medical board implements the changes needed to resolve the licensing delays. I submitted my licensing application in March, but it was not until August that I was notified that my application had a missing item. I immediately addressed the issue, but I've yet to hear when and if my application will be approved. Given the upcoming deadline in September, I risk being suspended from my clinical duties, causing an undue strain on my colleagues who would have to work extra hours to cover my shift. I risk losing the ability to pay rent in Los Angeles and may have to extend my residency training to make up for lost time. I'm a proud member of the Committee of Interns and Residents /SEIU. We are advocating for a transparent timeline. I hope the board will listen. Thank you so much.
Thank you for your public comment. Excuse me. Next public commenter, please.
Our next caller is Rachel McCarib with UC Davis. You may go ahead.
Thank you. Good morning. My name is Dr. Rachel Ekereb. I'm a PGY5 general surgery resident at UC Davis. Thank you for the opportunity to speak this morning. As a PGY5, I am part of the inaugural residency class to experience the provisional training license and transition to the physician and surgeon's license last summer. My year experienced significant delays during the processing of our physician and surgeon's licenses, and had the grace period not applied due to the COVID-19 emergency, I would have been unable to perform clinical duties for 6 weeks because my license would have been expired. This would have likely resulted in the extension of my residency training. As it has been evident this year, these licensing process delays were not a one-time fluke. There are approximately 150 residents at UC Davis currently awaiting their licenses to be processed, many of whom will be restricted from performing clinical duties during this time period, and some of whom submitted their applications more than 6 months ago, which is the time period currently recommended on the medical board website. This is impacting both clinical training and patient care, and is frankly unacceptable. We are requesting a more streamlined application process and a more transparent and expedited timeline for licensure processing. I respectfully urge the board to adopt these requests. I am a proud member and elected delegate for the SEIU Committee of Interns and Residents. Thank you for listening.
Thank you for your public comment. Next commenter, please.
Our next caller is Banur Chaudhry. You may go ahead.
Hi, good morning. My name is Dr. Timur Chaudhry. I'm a recent graduate after completing residency and 2 fellowships for endovascular surgical neuroradiology. Although already licensed and credentialed in 2 other states, I came to California to be with my wife in Sacramento to help with the statistics mentioned by Karen Go and giving back to the community in the Central Valley area and also Sacramento. However, just like other callers have mentioned, despite having applied very early, greater than 6 months, I still have yet to be issued a California medical license. My calls and emails go unanswered due to the delays in processing applications and staffing issues at the Medical Board of California. There is persistent lack of transparency in timeline and accountability. The analyst that was assigned to my application also refused to accept an original signed training form saying it was a copy, despite the attestation of my program director and coordinator, who herself is a notary. This further delayed the application, as medical board only reviews applications once a month, and they only issue out deficiencies one at a time, which further delay applications. From my perspective, this is delaying patient care, as hundreds of patients have already been rescheduled, and procedures as well. And not only that, in my specialty, we perform emergent ischemic thrombectomy, and that has been delaying and affecting patient care within the area. The lack of transparency and accountability in these delays and lack of staffing are causing significant difficulty for patients and also undue burden on physicians. California is already behind other states in developing streamlined stroke protocols due to these issues which remain unaddressed, as was presented at this year's Society of Neurointerventional Surgery annual meeting in July and August 2023. Although the board's lack of action and concern has already caused harm across the state of California, I hope this becomes an immediate priority to prevent further issues from occurring in the future. Thank you for your time.
Thank you for your public comment. Next commenter.
Our next caller is Max Blumberg with UC San Francisco. You may go ahead.
Good morning. I'm Dr. Max Blumberg, an occupational and environmental medicine resident physician at UC San Francisco. I'm calling to ask that the medical board remove the mental health question from the physician licensure application, both the PTL and PNS. 5 years ago, the Federation of State Medical Boards, a national body, recommended that all states remove invasive probing mental health questions from licensure applications for physicians. Although perhaps originally written with good intentions, there is no evidence to suggest that the current mental health question is actually protecting the public. However, there is strong evidence that invasive questions like those in California are a top barrier to physicians like myself from seeking mental health services when we need them. And a lot of us need them. 1 in 4 physicians experience a major depressive episode during our training, and physicians suffer from double the suicide rate compared to our peers in the general public. CIR-SEIU is advocating for removing the mental health question from physician licensure applications, and if the board has further questions, our member experts in the field have offered to give a presentation, and we would be happy to do so. I'm a proud member of the Committee of Interns and Residents of SEIU, and I respectfully urge the board to listen. Thank you for your time.
Thank you for your public comment. Next commenter, please.
Our next caller is Marion Hollingsworth, Public Patient Safety Advocate. You may go ahead.
Hello, can you hear me?
Yes, please proceed.
Hello?
Let's proceed.
Thank you. Good morning. My name is Marion Hollingsworth, Patient Safety Advocate. I would like to call your attention to the Public Citizen article that was released last week regarding California's state ranking for serious disciplines by this board. Public Citizen used disciplines sent to the National Practitioner Databank from 2019 to 2022 for this report. Disappointingly, the Medical Board of California was ranked at number 27. Despite all the claims that patient safety is your primary purpose, this board consistently fails to follow its own disciplinary guidelines, and time again has shown a distinct leniency to doctors personally known to board members and to CME members in leadership positions. Examples of this are a doctor who was arrested for a DUI with a blood alcohol level more than 3 times the legal limit. He worked as a surgeon at a clinic owned by a board member and just got a reprimand. There's also a former local CMA county leader who was given just 1 year probation after being found grossly negligent in a childbirth case. And there was a former CMA president who was just given a citation despite permanent harm to a patient in another childbirth case that resulted in a multi-million-dollar settlement. At the time of this doctor's case, 2 former CMA presidents and a delegate were on this board. And I don't need to tell you that a citation is not considered a discipline, so it doesn't have to be reported to insurance or the National Practitioner Databank. I urge you all to read the public report and then discuss how you can better protect California residents from dangerous doctors by not being lenient to those, especially with egregious cases and with those with ties to this board. Also, in a separate topic, the medical board phone app works fine if a consumer remains in the state but gives false notifications to people traveling outside California. 3 times in the past year I have traveled out of state, and each time the app floods me with a number of notifications for each doctor on my list, despite the fact that nothing had changed with any of them. I currently have 40 notifications on my phone right now. I had brought this up to your tech people, but so far nothing has been done. Perhaps the board can get this issue fixed. And finally, do you really expect there not to be a quorum tomorrow for the speakers on the childbirth harm? Is that the reason you are voting on leadership today? Not enough board members care about childbirth safety in California and Bakersfield in particular, Kern County, to attend tomorrow? It's rather telling, and you can do better. Thank you.
Thank you for your public comment. Next commenter, please.
Our next caller is Gloria Tavera with UC San Francisco. You may go ahead.
Hi, I'm Dr. Gloria Tavera. I'm an internal medicine resident physician at University of California, San Francisco, and I'm applying to stay here in California to practice gastroenterology in underserved communities, and I currently work at San Francisco General Hospital. I'm concerned about applying for the PTL and physician and services and surgeon's license. The medical board needs to make urgent, specific changes to address these licensing delays. Medical training is rigorous, and despite many challenges, we submit our paperwork on time. I'm about to submit, and I've seen many of my colleagues ahead of me experience job loss, missing pay, and lose thousands of dollars in life plans that were derailed because they couldn't perform clinical duties. My patients are having their appointments canceled because residents and fellows aren't allowed to do their job, which puts more work on me. We need a licensing process that is streamlined, reasonable, and transparent within 60 working days, and licensing that inquires only about mental health conditions, not in treatment, that impact patient care. I'm a proud member of the Committee of Interns and Residents at CIU. Thank you.
Thank you for your public comment. Next commenter, please.
Our next caller is Monty Goddard. You may go ahead.
Good morning. My name is Monty Goddard. I'm a California resident, a licensed civil engineer, and a patient advocate for my wife and others. Thank you for this opportunity to speak this morning. I congratulate you on last month's publishing of your updated opioid prescribing guidelines, and once again offer my wife and I and my associates sincere thanks for having done so. Over the last week, I have reviewed the video recordings of the meetings of the updated guidelines developed by Dr. Thorpe and Mr. Brooks' task force, and their ultimate approval by the full board. Your sincere expressions of caring for the desire to help those suffering in undertreated pain captured in those videos is remarkable and very much appreciated. Another thing my review of these video records drove home was the need for the guidelines publishing to be accompanied by an aggressive rollout to include coordination with not only physicians, but also the pharmacy board, pharmacists, the medical board, state attorney generals, the medical boards and state attorney generals, investigative units, health insurers, and corporate health care providers. This morning, I am asking for the how and when this rollout will occur. I'm sure those Californians now suffering undertreated pain will be willing to aid your efforts in any way possible. Effectively executing the board's repeatedly expressed intent to engage physicians, pharmacists, the pharmacy board, and the investigative units of the medical board and the state AG's office will require significant effort and skill. It will be no small undertaking, but its successful execution is critical to improving the ongoing plight of Californians afflicted with severe, chronic, or intractable pain. Thank you again for publishing your updated guidelines and also recognizing the criticality of this rollout.
Thank you for your public comment. Looks like we have three additional commenters on the line. Let's go to the next commenter.
Our next caller is Eric Anders. You may go ahead.
Hi, can you hear me?
Yes, please
Hello.
proceed. Please proceed.
First, congratulations to T.J. Watkins on his reappointment for another term. No, unless I'm mistaken, Government Code Section 54954.3 allows the public to comment on every agenda item should they want to, unless that item has already been considered. I wanted to comment on agenda item number 1, but you didn't call for public comment, so I'll do it now. I'm curious about board member Nicole Zhang. She seems to have missed more meetings than she's attended. Is there a requirement as to how many meetings someone can miss before their position on the board is called into question? I could be wrong, but it seems like in her year-plus tenure, she's only attended a couple of meetings. When there are patient safety advocates that would like to serve and aren't allowed to, why is she allowed to stay on the board and not attend the meetings? I have attended every medical board meeting since 2015. At each of those meetings, victims of family members of doctors that have harmed them have gotten up and told you their stories and pleaded with you to do more to protect us from these horrible practitioners. I dare say I've heard at least 100 of these stories just at these meetings. You all sit up there and nod your head. Some of you click away on your phones and laptops pretending to be doing something relevant. Others nod off. And then you thank us in your most sincere, caring voice for sharing our stories. Dev Gananadev used to placatingly say, "We feel your pain." No, you can't feel our pain. No one could sit on this board and listen to these stories and then be proud of being part of a system that is regularly and rampantly protecting bad doctors, and then say you feel our pain. My family has been struck by bad doctors 4 times now. 3 of them are dead because of it. We don't believe you when you say your priority is patient safety. We don't believe you when you say you feel our pain. We don't believe you when you say you want to hear from us. It's clear that none of that is true. You're just saying it because that's your job. Because the same complaints that I was hearing back in 2015 are true in totality today, 8 years later. So how can it possibly be true? So just know that we continue to watch you all, and we continue to not believe most of you when you pretend to care and pretend to protect us. The number and the cases show otherwise. Lastly, Richard Thorpe keeps talking to Randy Hawkins while others are speaking. That's not copacetic during a board meeting, as it doesn't become part of the official record for the public to see and hear. Would you please make sure that the board members know the rules that are expected of them and don't break them during the meetings? Thank you.
Thank you for your public comment. Next commenter, please.
Our next caller is Rosie Arthur's-daughter. You may go ahead.
Hello. I wanted to say that, first of all, access to this meeting was nearly impossible. The agenda items and materials were not sent out until midnight yesterday. There was no meeting information provided. There was no sound on this for 12 minutes. There was no audio at all, making it impossible to know what was going on. It took nearly a half an hour to finally figure out how to reach you. There was not adequate notice, and you're talking about being compliant with the Meetings Act, and your website says that you are compliant with and certified with ADA access, and of course that's not the case here, and that has been habitually a problem. That being said, I shouldn't be having to bring this up instead of having time to make the comments I wanted to make. So hopefully that's not a part of my time, because this is housekeeping issues that you should be aware of. No audio for 12 minutes is impossible, and then not even giving a way to access through the computer like you have been doing. There's no excuse for it. You have 3 months in between these meetings. You have adequate time, technology-wise, to make this happen. Okay. Now, my comments will be based on what the 8th call-in caller, Mr. Goddard, said regarding the pain guidelines. And those were issued. There was not a press release. The pain specialists have no idea that there's a new guideline or what changes have been made. They are still telling their patients that they have to taper them off of all controlled substances, whether they have intractable pain, whether they have a medical condition. It doesn't matter. That is what they're going to do. They are telling patients that Suboxone is safe for all patients. You go to the medical journals and they'll send out a thing saying that you should be using over-the-counter medications that are not safe for all patients. That makes a reference that they may not be safe, but doesn't say what those things may be. So persons with bleeding disorders or metabolism disorders that affect the medications they take, they're forgotten. People are sent to dermatologists for their Suboxone treatment, anything to get them out of a practice that treats a medication, pain medications. Or the fact that these will interact with mental health medications and other medications. It's not just controlled substances. It's any number of different substances. And it is still not being addressed in the pain guidelines. There was a request for an additional interested parties meeting on it. That did not happen. Granted, it's a start. It can be amended. We need to start amending it to make sure that these things happen. And like Mr. Gard said, there should be an aggressive rollout. How come the people prescribing pain don't even know that there's a new guideline? How come the people at different boards don't know about it? The pharmacists don't know about it. Why wasn't there even a press release? Just because it's sent out to people who are signed up for the newsletters and such doesn't mean that anybody else in the industry is paying attention to it. And if you're a patient or an advocate for a patient, you can't question your provider, because as soon as you do, you're out. You have to sign contracts, pain contracts, that say that if you disagree with your doctor, you can be expelled for no reason at all. So this is not right, and we need to get on with that. But people need to know there's a new guideline. But it's wonderful to have all these words, all this concern. But if there isn't anything to back it up, if you can't point to it and say, look, here's the guideline, here's what it says on page 12, or whatever, it doesn't help. Anyway, thank you very much. I do appreciate your efforts. They definitely need to be there, but we need to start working on making it right and letting the public know and the providers know that there is a new guideline and they don't have to taper off all of their patients, and particularly to make medical conditions worse. Anyway, thank you very much.
Thank you for your public comment. Next commenter.
Our next caller is Taisha Watts. You may go ahead.
Hi, good afternoon, board members. My name is Taisha Watts with the California Academy of Family Physicians. We are appreciative of the opportunity to comment on agenda item 9A pertaining to postgraduate training license. CP has received numerous inquiries from our members regarding resident physicians facing significant challenges in obtaining PTOs and experiencing delays in transitioning from a postgraduate training license to physician and surgeon's license. Without full and unrestricted licenses, physician residents cannot receive hospital privileges or get credentialed with health plans, which pose significant challenges for physician residents in healthcare delivery. In the upcoming months, a vast amount of our residents' PTOs will expire. We are appreciative of the NBC's willingness to prioritize this matter and to propose extending PTOs to March 2024 for PTOs that will expire between June to December. We believe this will help to combat processing delays and access to patient care. However, we do have concerns that future challenges to attain PTOs remain. We encourage the board to work to prevent future processing delays and implement a transparent timeline for processing applications. We look forward to working with the board to resolve this matter and are appreciative of the staff who are working diligently to resolve this problem. Thank you.
Thank you for your public comment. Was that the last comment on the line? Are there any additional commenters in the room that would like to speak before we close the public comment period?
Madam Chair.
Yes.
I don't know why we can't get a reasonable audio, but much of the public comment was very difficult to understand and almost unintelligible, most of it. There were maybe 2 commenters that I could actually understand. And that's just not acceptable. I can't make decisions, I can't have input unless there is some kind of real, clear interaction. And I know it's not, I realize it's a difficult position that the board is in, but I just want to say that I am not pleased with the technical support. And I know there's challenges. I'm not trying to call anybody out, but I'm just saying it's impossible for me. I don't know how the rest of the board felt, but it was very difficult to understand. Even the in-room comments were very difficult because the people at the microphone didn't understand that they have to speak right into the microphone to be able to be heard. So very difficult to understand people's names. This whole public comment thing was I just feel like it was poorly done, and I'm not blaming anyone, but I'm just saying it is challenging because we can't make comments, we can't have input as a board unless we really understand what people are saying. And much of what was said today was very poorly, for me. I know I have a hearing difficulty, so that's a problem. That's my problem. But it was very difficult to understand, and I just want to go on record as saying that I am not comfortable with what we experienced today, and it needs to change.
Also, my comment, there was a comment about Dr. Thorpe's and I communicating. We were asking each other, can you hear that? What is the person saying?
Exactly.
That was the purpose of our communication.
Perhaps, I don't know if the technology on the WebEx is better, but I can hear and see those things better when we have a WebEx-based call, and it's easier to follow. Maybe the technology difference is just enough to put us over the line so that we can all understand and, address some of Dr. Thorpe's concerns. I could hear, but it was taxing. So.
Like Mr. Watkins, I could hear it was taxing for some of the callers. Some of the callers' audio is clearly coming through. And when we try to manage a variety of technologies being used by all of the commenters and then our own technology, what I will say is in board meetings prior to WebEx, this was a persistent challenge for us as well, right? There's a lack of uniformity of various platforms. And when we all went to Zoom and WebEx, all of a sudden we could all hear clearly from our computers, and now we're back to being here. I would invite you, if you want to sit closer to the...
That's not the issue.
I clear my throat. If you want to sit closer. It is easier to hear if you're closer to the speaker, but it was for sure taxing. So we're going to do our best here with the resources that we have. Our team is doing a terrific job trying to manage everybody who wants to comment through all various platforms. Some boards and bureaus only allow, a comment in one way or another. So we're trying to make this as accessible as possible to as many people as possible. Dr. Mahmood?
Yeah. I'm almost every day in some meeting, which is telemeeting and kind of stuff. I haven't seen this poor performance ever. It is not just one system and kind of stuff. I think we need to make an improvement. If we cannot hear anything, we cannot understand anything right, then we cannot say this is terrific work being done. I think there's a lot more improvement needs to be done. I echo Dr. Thorpe saying that honestly, 80% of things I couldn't understand.
Is there anyone who can't hear the people here in person?
Because
we're here in person in Bakersfield to have a meeting in Kern County, and it's really important that we continue with the meeting. I'm not going to stop the meeting right now to figure out if we can alter our technology. We're doing our best. And so to the extent that there are commenters on the line where they're concerned that we can't hear them, please do email your comments to the board. Those comments get to us directly as well. And so you can make sure that we heard exactly what you said by sending those. And I think that the email address is webmaster@nbc.ca.gov. It's on the agenda. So to the extent you're concerned that we weren't able to hear you, please send those in via email, and we'll make sure all the board members have those communications. But we're going to proceed with the meeting as it is here. During the break, we'll evaluate whether or not there's some change we can make that will help us here going forward. But I would really not like us to take time away from the time we have here in Kern County so we can argue about whether or not we can all hear perfectly.
May I approach to modify a comment?
Nope. I'm sorry, where the public comment period is over.
It's over with completely?
Yes.
When will there be more public comment?
We'll be taking public comment on each agenda item.
Okay, great.
Thank you.
Thank you. God bless.
We are going to move on to agenda item 3, which is approval of the board meeting minutes from May 18th and 19th and June 29th, 2023. Would anyone like to make a motion to approve those? Or are there any changes or comments?
Motion to approve.
Thank you, Dr. Ballot. Second from Dr. Helzer. We will now open this for public comments. Are there any public comments in the room on the board meeting minutes? Okay, seeing none, are there any comments on the line?
At this time, we have no callers on the line, but again, if you would like to make a comment, please press *1.
Okay. We'll just give it a minute. No comments? Okay, we'll bring it back to the board. Ms. Lopez, if you could please perform a roll call vote, unless anyone has comments.
Dr. Ballot?
Yes.
Mr. Brooks?
Yes.
Dr. Hawkins?
Yes.
Dr. Helzer?
Yes.
Mr. Watkins?
Yes.
Dr. Mahmood?
Yes.
Dr. Sai?
Yes.
Dr. Thorpe?
Yes.
Madam President Lawson?
Yes. All right, the May 18th and 19th and June 29th, 2023 board meeting minutes are approved. We are going to move on to agenda item 4, which is the president's report. I just have a couple of very brief updates and comments. I wanted to again thank the Bakersfield and Kern County communities for welcoming us here to Bakersfield. We are really grateful for the opportunity to be here with you in your community. I believe this is the first time the Medical Board of California has held one of its quarterly board meetings here in Kern County. I know over the years there's been a substantial amount of outreach to the Kern County community from our staff, but on behalf of the board, we are really pleased to be here in your community and really look forward to the opportunity, particularly tomorrow, to learn from so many experts, hear about the maternal health crisis and issues you're facing here in Kern County specifically. We will have someone here to speak from Kern County, in addition to a number of experts from across the state and other jurisdictions as well. So thank you again for your hospitality over these days when we're all here, and we look forward to the opportunity to continue to connect with you. I wanted to just note there are a couple of our key staff members that weren't able to be here with us today, some of whom worked tireless hours to prepare this agenda and make sure that we had a good, positive meeting here. Some of our staff members are affected by natural disasters going on in locations across the state, and I know that they wish they could be here. So I want to thank Carrie Webb in particular for all of the work that went into preparing this agenda, particularly tomorrow. I know she wishes she could be here with all of us. I also wanted to acknowledge the medical and public health communities who are on the front lines of helping respond to these natural disasters, whether it be a hurricane or a wildfire or an earthquake. I wanted to acknowledge that obviously there's a significant public health response that goes into managing those types of disasters and crises and extend our gratitude. I also wanted to extend our gratitude to the first responder communities and to the physicians in Orange County last night that were tasked with responding to yet another mass shooting. These types of shootings, mass shootings, are a public health crisis in our community. And while it doesn't fall squarely within the jurisdiction of the medical board, I think it's, again, worth us extending our gratitude and acknowledging the public health crisis. In terms of updates since the board, since the last board meeting, which I regrettably was unable to attend, I did have the opportunity to swear our new executive director, Reggie Varghese, into his position, taking over from the interim position and now being the executive director. I had the opportunity up in Sacramento between the last board meeting, and I know we are also now in the recruiting process for a deputy executive director, and perhaps Reggie will address that during the executive management reports. I also just wanted to call the board's attention to your email. The enforcement monitor, final enforcement monitor report was issued just last week. And so to the extent you haven't had an opportunity to review that final report, I commend it to you. I think there are a lot of worthwhile suggestions, recommendations, observations in that report. So it is worth your time to read. You should have a link in your email. The report last week was also sent, as far as I'm aware, to all of the legislators as well. And then, we have been quite hard at work on the board's sunset bill, SB 815. I'm not going to spend too much time talking about it now because we're going to talk about it shortly. And Aaron Bone will be joining us, I think by Teams or by phone, to help walk us through that. But suffice it to say, there's always a lot going on when it's a sunset year. There are lots of conversations on a variety of topics. Dr. Hawkins and I have been, as your representatives to that process, have been engaged in numerous conversations over the course of the summer, and in fact, just over the past week or so, as we reach what I'll characterize as the home stretch in getting the sunset legislation across the finish line. I am particularly pleased with how collaborative the process has been this year, working with the legislature, working with the Department of Consumer Affairs, working with agency, working with a variety of stakeholder groups. So I'm just very pleased at how collaborative the process has been. Of course, it's a give and take sometimes in these circumstances. We are unlikely to get every single thing that we asked for in this process, just like other stakeholders are unlikely to get every single thing they ask for. But the spirit and the collaboration and the communication has all been very productive and positive, in my opinion. And I highlight that because it feels like a change from years prior, where there was some real tension and perhaps frustration on our part and the part of others during this process. So, like I said, we are not across the finish line on the sunset bill yet, but we can see that in sight. So with that, I'll invite any questions of me. Looks like Mr. Varghese wants to make a comment.
Madam President, before we go into public comments, just want to make sure that, did we approve June minutes?
Yes, we approved them all at
May
the same
and June
time.
together. Okay, thank you.
Yes. Dr. Thorpe.
I would just like to change the tone of my comments from previously. But I would like to say thank you to you and to Mr. Watkins and Ms. Lubiano for the tireless work that you've put in on the Sunset Review bill, and also on your recognition of the need to have this meeting here in Bakersfield. I think it was really perceptive and an example of the leadership that you've provided. And I know this is this may be your last meeting as president. I don't know if that's true or not, but
I suspect it will be, but we'll find out on agenda item.
We may vote you in again.
Agenda item 12.
But before that, I just wanted to personally say thank you for your diligence and service to us and to the state of California.
Thank you. I appreciate that. Other comments before we take public comment? Okay. Seeing none, are there any public comments in the room on the president's report? All right. Seeing none in the room, are there any on the line?
We have none on the line at this time.
Okay. We will move on to agenda item 5, board member communications with interested parties. Do any board members have any communications to report regarding items that will be coming up for discussion during this meeting? Dr. Blat?
Sure. Thank you, Madam President. I have been in contact with April Dozal. She's a political coordinator for the community of intern and residents of the SEIU healthcare, and various program directors throughout the state, not just UC, so various program directors. And I know the challenges that we have, and I appreciate everything that you and Mr. Varghese and the rest of the board are doing to that end to address the issue of the PNS to the PTEL.
Thank you. Mr. Brooks? None? I'll just go down the line. Dr. Hawkins, do you want to?
Yes, continue to involve with local and national societies representing the medical board, the importance of physicians and physicians in training, Food and Drug Administration advisory committees on vaccines development, and the PA board.
Thank you. Dr. Thorpe?
Just to mirror Dr. Blat's comments, I mean, I have also been in contact with a number of program directors and individual applicants concerned about the extended timeline for obtaining licensure.
Excuse me, Dr. Tsai. Any contacts, Dr. Helzer?
I've also heard from concerned program directors and applicants about licensure delays.
Thank you. Dr. Miller?
Yeah, I've spoken to April from SEIU, CIR, as well as several candidates whose license has been delayed significantly. A lot of concerns on that.
Thank you, Mr. Watkins. Any communications? No. Thank you. And as I mentioned during my president's report, I've had a number of communications, whether that's with legislators and their staff. I've met with SEIU and others who have interest in the sunset and other legislation. I've also met with other legislators who have other bills that have some relevance here. And I, like most of you, have heard directly from certain residents. Most of the time, I pass those along directly to our staff for follow-up. Okay, are there any public comments here in the room about board member communications? Or any communications commenters on the line?
No comments on the line at this time.
Okay, yes, you have a comment. This would be on board member communications with interested parties.
Am I an interested party?
This is the public comment period is to comment on our reports of communications with interested parties. If you'd like to do that, please come forward.
I don't know if this applies, but I'll try. You can just stop me if it's not appropriate. The communication with me for a complaint.
Please speak into the microphone.
The communication that I experienced after a serious complaint was almost non-existent. I mean, there was a process, there was an investigation, but then I heard nothing for years of the resolution, no matter how many times I called or emailed. And so the communication was very poor as far as that.
Thank you for your comment.
There is an impasse as far as the communications, because what we're finding when we make our comments or our complaints or whatever to the board is that there's such a time gap that we have no idea what's going on. And you keep calling and you're just continually being told, well, we can't tell you anything. And so I'm just begging you guys not only to increase the staff on the DOJ end with those people, get a bigger group of you guys. Increase, because if we're in one county here has over 9 million people, this is not Virginia. Okay, so we need more of you guys working and to make there be a better, a smaller gap, that is, in the communication, because we've been waiting since, September of last year. It's a bit long, that to be keeping somebody in refrigeration waiting for you guys to get back with us. Love you. Thank you.
Any other public comments? Okay, let's move on to agenda item 6, executive management reports, and I'll turn that over to you, Mr. Varghese.
Thank you, Madam President. Respected board members, I would like to go over the management reports that starts on in your notebook, page 6A, page number 1. So the first part of the report, I just want to report out that, as usual, we have several conversations with Board President Christina Lawson and Vice President Dr. Hawkins on a regular basis on ongoing projects and meetings and agenda planning and such. And we also meet regularly with the Attorney General's Office, HQIU staff, the DCA Department of Consumer Affairs staff, and State Board of Pharmacy, State Board of Nursing, State Board of other State Board Healing Hearts, California Department of Public Health, Department of Social Services, Hospice Fraud Task Force, and also Federation of State Medical Boards. And these are all in relation to the business and day-to-day business and other aspects of the board. How do we carry on with those? And moving on to staffing updates, this continues to be an issue with the board. We still have a 17.2% vacancy rate, which equates about 31% of our positions. Even though we welcomed about 50 new employees between April 1 and August 16 of 2023, there are employees who started with us, decided to leave, or some of those vacancies were filled with internal positions. But at the same time, I just want to say that we are working with the DCA HR to expedite hiring process, and DCA is assisting us very much in finding more retired annuitants. So those hirings are faster, so we can get them on board faster. And like Ms. Lawson alluded to, the Deputy Director recruitment process is going through. The application online is closed. We do have some applicants which we will be evaluating and making a decision soon. Moving on to much important item here, the budget update. As the board know that we took a $10 million loan from another DCF fund in 2021-2022. The board's funds are at 1.6 months reserve in the positive range at the end of 2022-2023, and that's only because we took another second loan in the amount of $8 million from another DCF fund in 2022-2023. So these loans must be repaid, and that is a fact, with interest in 2023, starting with 2023, 2024, and the second loan of $8 million in 2024, 2025. So the important fact to note here is that unless we secure the additional fee increase that we requested, then by the third year from now, our fund balance will go into the negative territory. And I would draw your attention to page 6A, section 6A, page 27, which we will be going over here soon, show the impact of no fee increase, how that's going to affect our fund balance. More to come on that later. Moving on to media relations and external communication updates. So on August 15, 2023, an e-blast was sent to all postgraduate training licensees to inform them that their license will be expiring in September of 2023 and do not have an open application at this time at the board. So even at August 15, even though their license was going to expire in September, we didn't have an open application received at the board. And also several e-blasts went out to others, alerting them to the importance of applying early. And on August 11th, we published a web page that shows the processing time, which is, correct me, Marina, if I'm wrong, I think it is refreshed pretty much every day, which will list what is the processing time for each application categories. On August 27, we published our second quarter edition of newsletter. August 21, 2023, the board's physician license regarding update to guidelines prescribing was that matter was sent out to all licensees and our listserv members, alerting that this publication is out there. And there were other outreach efforts too in that by various different organizations, and we thank all of them for taking an effort on our behalf to send the board out to the community. This is an important initiative that board was able to accomplish. And moving on, May 22, 2023, an e-blast was sent to all PTL holders whose license expires this year, reminding them to submit an application to transition to PNS license and encourage them visit the board's website for more information. And also there was some information sent out to the general public through various social media about the heat wave this summer. Regarding the remote working updates, there was no change from the previous update. Going on to physician survey redesign, as of August of this year, over 79,730 licensees have completed the survey. So something new we started to put in these reports is a graphical interface or representation of these numbers, because these numbers kind of get lost, and you will be able to see how that survey statistics started back in 2022 July and through how it is progressing through July of 2023. Moving on to complaint tracking system, August 2023 update is that the second interested parties meeting of the complaint tracking system was held on June 21, 2023, and was attended again by Dr. Bolat and Ms. Lubiano. Public comments and suggestions were heard during an approximately an hour and a half duration of that meeting. So during this meeting, we went over the previous items that were identified in the first meeting, and then at this meeting, we learned about 4 new items that were added to the suggestion box. At this point, our goal is to bring it, work with the legal division to go over all these suggestions, and then bring it back to the November 2023 meeting for your consideration for taking this project to the next stage. Going over to page 4, print yourself your wallet card project is again having much success out there and adoption rate. We from December 2021, according to the line graph, you can see how that increasing, that adoption rate is increasing as we go forward. And this is really saving the board cost of printing and mailing very expensive plastic cards. So this is a very good change that we switched over to. Going over to direct online certification submission portal, which we usually refer to as DOCS portal. As you can see from the graphical interface there, that from 2019 to 2023 June, the adoption rate is really high, especially the month of June. It just went really high to all of our amazement here. And this is really encouraging news also, because this really speeds up the process for the programs to submit their documents on behalf of the trainees to the board directly. They don't have to wait, mail it in, and then once we get the mail and postal mail, we have to do the manual process of opening the mail, scanning, and adding to the record. So this is really encouraging that there's much more adoption rate out there for the DOCS portal. Online complaint form redesign. This project was delayed, as I reported several times before during the last year or so, but now I'm happy to report that this project is being funded finally, and Department of Consumer Affairs Portfolio Governance Council, or the PGC Council, approved the funding for this project, so we will be seeing some movement on this aspect very soon. In addition to the prepared remarks here, I just wanted to report that several meetings prior, board members have expressed an interest in us pursuing some form of automatic email sent to the applicants upon issuance of a physician surgeon license, and also the physician training licenses when they're issued. Why don't we automatically remind them? I'm happy to report that those 2 projects are live now. So on a nightly basis, those automatic emails will go out to anyone who get licensed during that day. So moving on to next page, which is the monthly breakdown of Attorney General billing. And this is through the month June of the last fiscal year. And on page 8, you will see that the total budget was $16.8 million we started out this year with. And through June, we only spent $14.6 million. That means we have a surplus in that budget for Attorney General's billing in the tune of $2.24 million this fiscal year. The next page, basically page 9 and 8, that is a representation of Attorney General's budget for the licensing aspects. There's also a $14.7 million surplus. Page 11 and 12 This is Attorney General's representation for the midwifery program. According to the report here, we actually overspent the budget on that. The only budget $32,000. Again, these items are not really easy to budget because what we spend for Attorney General is based on what cases that comes our way. We cannot really predict that when we are preparing the budget. So based on the task at hand and the caseload at hand, going forward, hopefully we can have a better budget so we don't have a deficit like this going forward. Pages 13 and onwards, this is a 3-year expenditure projection report. The first 2 columns in the green shaded columns are the actual expenditure items for FY 2020 and 2021, 2021, 2022. The next column, the blue highlighted budget, is for 2022-2023 fiscal year, which is this last fiscal year we just ended. And the budget column is there, and year-to-date and the encumbrance added up to the year-end projection, and the balance is the last column. I would not want to, in the sake of time, don't want to go through each line item, but just to know that on page 15, you will see that we, as of June, we have a surplus in our budget of $10.7 million. Again, keep in mind that we haven't paid all our expenses as of June 30th. Bills will be coming in month 11, 12, and 13. So usually after 3 months after the fiscal year is closed out is when we have a true picture of how much we spent for the previous fiscal year. Page 16 and onwards is some new reports that we staff thought would be interesting to the board, and these are all Attorney General's legal matters. Now, I'll do my real effort to justification to explain some of these, but later in agenda item 7, we'll have Attorney General's budget representatives, staff will be here. So if we have any questions that I cannot answer, I would definitely have them fill in for that. The first report here, this shows, again, at the bottom of those pie charts, you will see the total budget of $16.9 million I mentioned before. And of that, 57% of that budget are spent for these matters, like acquisitions, 87%, and acquisitions petition for revoked probation, 4%, investigation, which these are joint investigation with CIO and HQIU that Attorney General have to spend money on. Also, you would see those references, call-outs, and later down below these reports, there's a legend that you can read upon what these different pies are. And page 17, this represent interim suspension orders, BPC 820, which that is the order issued for mental and or physical evaluations. Those categories that represent about 3% of the total budget. About 86 is the total number volume that Attorney General spent money on during the last fiscal year. Page 18 represent the subpoena enforcement and subpoena defense, 4% of their total budget, and there was about 84 of such cases, and we spent about $694,601. Page 19 represent civil, state, and federal matters. These are legal representations of MBC staff and board members, and in federal or state courts filed by individuals who are challenging state law or disciplinary or outcomes of this board. So Attorney General's office represented this board. Their total budget, 51% of this section here, 51%, about close to $1 million was spent in civil and state federal lawsuit defending the board and the staff. Petition for writ, which are filed by licensees in Superior Court to review board's decision. And there's also 5% of the money was spent on civil penalty, and then also 13% was on appeal-related representation. Page 20, Attorney General spent these fees in petition for penalty relief, and these are petitions filed by licensees for early termination or modification of probation. And that's about 60% of that category there. And also petition for reinstatement is what it is. Those licensees whose license was either surrendered or revoked will have a chance to apply for reinstatement. Again, Attorney General's office represented us, and then we spent about $261,473 in that regard. Page 21, 22 are just those legends. Will explain in detail what those categories are. And page 23 is our general expenses related to various different aspects, and that's about 6% of their total budget, or for our budget that we set aside for AG's office. Page 24 represent a graphical representation of last 5 fiscal years of Attorney General's budget to the actual. And you say, as I alluded to before, last fiscal year, we have a $2.some million left over in the budget. We did not spend all of that money. Compared to the previous fiscal years, we overspent the budget. Page 25, this is an accounting through May of 2023 of how much cost recovery we collected since we were able to collect money for cost recovery. June numbers are not available, but these reports, if board pleases, would be part of this board meeting packet going forward. And on going over to page 26, Page 26, this is our fund condition report. There are 2 fund condition reports I would like to go over with you. The first one is a representation of if we, it's not if, but once we get our fee increase, how it's going to look like, right? So just wanted to draw your attention to this report. This report must be read from the left column top down, and then move over to the next column top down. So it shows the previous year of 2020 to 2023, and those blue highlighted lines are the money that we anticipate to bring in once the fee increase is effective January 1, 2024, right? So that's SB 815 is calling for. So when you go down the line there towards the middle, you will see that $8 million loan that I referenced before. So that's where we get the bottom of the months in reserve of 1.6. Then that money is carried over to current year of 2023, 2024, where we have to pay that $10 million back, which is with interest. So that is 10.16 that we have to pay back. Then we are hoping that, we are thinking that we might need another loan. Right now, to keep the fund balances in the positive range, we think it is about $27 million. It may or may not be that, but based on the numbers that come in May and June, how much cost recovery, that may be less or maybe more. We don't know that yet. So, and then the next 2 columns, 2024, 2025, we have to pay the $8 million back, which is we're anticipating with interest 8.523. And then the following year, we have to pay that $27 million in the tune of 28.765, that is with interest. So this model will work to keep our fund balance float in the positive range only if we get the fee increase. So moving over to page 27, this is a representation of not getting the fee increase. And I don't have to go over all the numbers. You can see what the bottom line looks like. Moving over to enforcement program summary. We have various, as you know, we have a expert review program, and currently we have 723 active experts in the board's expert database. One new thing that I want to share with the board, that the expert program staff have already started on a process of moving the expert training from in-person or online in-person training, which is synchronous training, to something like asynchronous training, meaning that they can take the training on their pace. Right now, it is a lot of resources need to be pulled in to get the trainers and lined up, and the physician who are training or the experts who are getting trained have to commit the entire day of a weekend, Saturday, to come to the training. So we are trying to move away from that and create an asynchronous training program that they can take on their own pace to increase the number of trainings and also the number of experts getting trained on. So that initiative is already started. So we'll report to you as soon as that's in place, and hopefully sometime in the near future. The next expert reviewer training, which will be an in-person WebEx or synchronous training, would be on October 7th, 2023. And if any board member are free to attend, commit your entire Saturday, please welcome. You're welcome to attend. Central Complaint Unit, CCU. They right now, to initiate a complaint in CCU, it's like 5 business days as of the fourth quarter of 22-23. The average days to complete a process in CCU is 112 days. Complaint Investigation Office, CIO, their caseload is about 230 cases at this point. And during this last quarter, they closed about 43 cases and transmitted 14 cases to Attorney General's office, and in various different violations, criminal to malpractice to vaccination exemptions, fraud cases, petition to reinstate. Additionally, the CIO referred 2 cases to board cite and fine program and 2 cases for PLR. Discipline Coordination Unit is actively filling vacancies right now. They're making good progress, and that hopefully by this next quarter that DCU will be fully staffed, which is important because they do very important work in processing the final adjudication of a complaint, working with the Attorney Generals and bringing those cases to board members during the panel meetings. Probation Unit also is actively recruiting to fill vacancies at this time. And at this time, and what follows after this report is all the charts. They kind of have a graphical representation of some of the materials that I went over right now. Moving over to licensing report, in the quarter 4 fiscal year 22-23, the board received 1,890 initial licenses, and out of that 1,377 are physician surgeon and initial license, and also 513 postgraduate training license applications. On June 1, 2023, the board stopped accepting paper application for physician surgeon license and successfully transitioned all PTL and PNS license application to online only, which is a major effort, and we haven't start seeing the full impact of that yet, but hopefully when we go from starting January 1, 2024, when we will no longer accept documents from medical school and postgraduate training program through mail, and we will only accept documents through Docs portal, we will probably make the full circle and try to get somewhat move away from paper processing and speed up the application processing. And at this time, there are other challenges that we are facing in licensing, as we already heard from some of our public commenters. But I just want to assure the board that some of the comments that you will hear from me and later down discussion to tell you that we are doing everything in our hands right now to push all those physician surgeon transition PTL transition application to PNS and cut down on the workload. And licensing staff is working diligently right now. We have received some external help from other departments within MBC that are coming in and helping to process application. We are working overtime. We do have other staff members from DCA coming in help. Recruitment is at a faster pace. And if you have more questions on that, I'll have Marina elaborate some of that when I conclude my remarks here. And Consumer Information Unit is very active. We received 16,358 calls this past fiscal year, and the average wait time on those calls is about 5.08 minutes. Outreach is picking up pace as we speak. The licensing program attended 3 in-person outreach events and provided 2 virtual outreach presentations at accredited postgraduate training programs, orientation events where licensing staff answered application questions and provided feedbacks. And we hope to increase the volume of outreach efforts that we conduct out there at the schools, and we are urging the schools to inform us when there's a chance for us to come and speak to their applicants so we can guide them through the application process. So when they complete with that orientation with us, they know how to fill out an application completely, first time, and in being compliant, so there's less chance of deficiencies and delay going forward. So that kind of concludes my prepared remarks, Madam President. If board members have any questions for me, I can answer the best I can, or I have Jenna, Chief of Enforcement, and Marina O'Connor, Chief of Licensing, is here with me. Thank you.
Thank you, Mr. Varghese. Are there any questions, comments from board members? Dr. Helzer first, and then we'll go to Dr. Thorpe.
Thank you. I have 2 questions. Mr. Varghese, regarding the cost recovery figures on page 25 of your report, we all see the judgments that are included in the various decisions and stipulated settlements. What % of those judgments do we actually collect?
So our goal is to collect 100%. Now, the judgments sometimes are agreed upon at a lesser amount of the total cost that we spent, and that's sometimes to get to the settlement. And then right now they have certain amount of days to pay that. If they're on probation, if they don't pay that, they're in a violation, right? But they can also go into a payment arrangement if they cannot pay all of that in a lump sum. The only caveat is that if the doctors agree to surrender or their license is revoked, there's no cost is recovered at that point. It is recovered when they try to apply for reinstatement. And if I'll let Jenna Jones mention anything, if anything else to add on that.
No, sir, but something to remember is we were only able to begin recovering costs incurred after January 1, 2022. So as time goes on, those investigations that are completed, after that time will be included in the recovery cost. Whereas the first 6 months of 2022, many of those cases had no investigation cost portion of the cost recovery because they were completed in 2021. So you will see those numbers grow as time goes on, and we're trying to find better ways to track and keep track of all that for you. Thank you.
Thank you. May I ask my second question, too? Okay. My second question is about licensing. At our last meeting in May, we learned that the average backlog was around 84 days, and it's now around 120 days. What has happened in the interim?
I'll let Marina comment on that. Thank you.
Yes, thank you for that question, because you're right, it has grown a lot since that time. We've faced a couple challenges. One is we did try to do a lot of outreach to applicants and programs to make sure they apply early, because we already had a backlog and there was the potential for it to grow more. Unfortunately, most applicants still apply closer to when they're going to need the license. But in recognition of we had already had a backlog, we knew it could get worse, we had tried to ramp up recruitment of permanent positions as well as bring on temporary staff. Mr. Varghese mentioned retired annuitants. Those are easier to bring on than a permanent employee because it's a different process to go through, but that also took a long time. And those were the challenges we faced when we were trying to ramp up our staffing to meet that demand.
Thank you.
Dr. Helzer, I also draw your attention to page 9, 6C, page 9. There's a bar chart there that shows quarter 3 and quarter 4 are applications received as compared to quarter 1 and 2. And simply, this is the volume just dumped on us, period. The last quarter when they really needed the license. And so having staff shortages and this many applications just added onto the pile, that's also a factor. But again, that's not an excuse. This is something that we anticipated because the law changed. A lot more applicants were eligible to apply for physician surgeon license, otherwise they wouldn't have. So those are factors. There are several factors. Again, we were trying everything to make sure that no one is left out there without their unexpired license. So we'll do our level best to get there. Thank you.
Thank you.
If I may add as well, I know Mr. Verghese mentioned this, but we are on track to get all of the applications for those PTLs expiring this year, specifically the ones by September 30th. That's a major deadline for a lot of PTLs that are expiring. We're on track to have all those applications reviewed before September 30th, and we're doing it in order of the PTL expiration date to make sure they're reviewed before their PTL expires. One of the challenges is most applications are deficient at the time of review, which means they're missing either a required document, that we need to review to ensure they meet the licensure requirements. So that is one of the challenges, we're facing, even though we're reviewing reviewing the application well before their PTL expires, there's usually a deficiency. So we still have a lot of those documents coming in after review that we're trying to also make sure we're keeping that moving forward so that we can issue as many of those licenses as possible by September 30th.
I just wanted to ask a question right along these same lines for clarification's sake, because Mr. Verghese, you referenced the previous legislation putting us in this position of having these expirations come perhaps in these batches. Could you just, I think there are some board members here that weren't on the board during the last sunset review when that change was made. Maybe you could just remind us of that change and again, sort of why we're in this position now.
Absolutely. So starting Jan 1, 2020, that was the creation of the postgraduate training license. And it also changed the training requirements to obtain a physician surgeon's license to 36 months of training required. It was previously 12 or 24 months, depending on where you graduated from medical school. But in 2020, they changed that to 36 months of training for everyone. And then in Jan 1, 2022, it was changed back to the 12 or 24 months. So you had previously a postgraduate training license for 36 months. Now you only had it for up to 15 or 27 months. It's a much shorter time to obtain a physician surgeon's license. So when that law change happened, Jan 1, 2022, we had a surge of applications, almost double the number of applications we usually get, but we weren't authorized any additional positions until July 1, 2022. And by that point, we already had a backlog. And with the hiring difficulties we've had, it only exacerbated the problem. We often experience, even since 2020, when the PTL was first created, we pretty much kind of know when we're going to see just our normal surge of applications, right? We have our ebb and flows throughout the year. And typically with normal staffing resources and normal application volumes, we are able to meet that demand. However, with those two major factors, huge surge in applications that unfortunately did not come down in 2023. We were hoping we'd see, okay, after the law change, maybe things will kind of, there's an initial surge, it would start to come back down in 2023. It has not. It has actually grown a little bit. I'm hoping it doesn't continue to grow. I would expect, because it's hard to see after a law change what your new norm is, but now that we're in the second year, we can probably expect this to be the new norm. But with that constant high level of applications, the difficulty of filling positions and even bringing on temporary staff has made it very hard to meet that demand at those normal surge times that we see, and which is why we tried to get somewhat out ahead of it by telling folks, apply as early as you can. We have a longer processing time now, ramped up outreach to programs, conducted live webinars, lots more notices, as Mr. Verghese mentioned, going out to licensees and applicants, reminding them to apply and that make sure you get it in, your PTL is going to expire. And so that's what we're trying to make sure right now is DCA is helping us fast track our hiring, making sure we're getting on the staff we need to eliminate the backlog, but we're also having to use our existing resources from other units, even within licensing, redirecting staff to make sure that we get those apps reviewed and as many of those licenses issued before that September 30th deadline. And we are on track to do that, so I'm very confident we'll have all those applications reviewed.
Dr. Mahmood?
On this review process, is there a way we can do something like more frequent and quicker review? Because review is going too late, and when you find the deficiencies, they don't have the capacity to get that done, and their whole thing is delayed. And when somebody is living on that thing that they cannot even pay their rent or their other things, and their license not processed in right time, it's going to be a huge challenge, and that's what we've been hearing. So is there a way that we can really reinforce at least the review process, which is in our control, so that people know what they are deficient and they can get it done as quick as possible?
Yes, Dr. Mahmood, I'll just start off and I'll let Marina add in if anything that I missed. And actually, it's in the analysis on page 6C1. I didn't really read verbatim everything that's in there for the sake of time. We have looked at streamlining the process where we cut out certain duplicative efforts or things that are not really required by the law are being taken out of the process to speed up the process. One example is that the board no longer requires a certified copy of the diploma of the PTO if there is a transcript available. So just one example of many processes that are being cut out from the line to speed up the process. At the same time, when an applicant calls in to the call center or to one of the other customer service, and if they say that their license either expired or going to be expiring sooner, or our call center is asked tuned to ask that question too. So if it is nearby, we'll try to expedite those as soon as possible. Marina, if I left out anything, you can chime in.
Yeah, no, the diploma is a great example. We've actually started this process of trying to evaluate our internal processes, what we can cut down and make more efficient. For years, we've been going through this process. We've cut out a lot since probably since 2020, early 2021. We used to require the paper app to still be mailed in, even though they were completing an online application, and require it to be notarized. We've cut out all of that. Most of those documents do not have to be notarized anymore. Docs has been essential in that. If they submit a document through Docs, it doesn't have to have a seal, a notarization, which was crucial during COVID when people were staying at home and not able to get, everything maybe notarized as easily as they could, or a seal on a document. So we have been making progress, but in light of the current situation, we've gone much further. We're looking at these transition applications, and we've already cut out a lot of the, we do a lot of extra review, because it's obviously very important to make sure that before we issue a license to someone, all of our T's are crossed, I's are dotted. But we've cut out a lot of steps and review time that we think we can do with these other changes we've made and still ensure they meet the requirements for licensure and that they're safe to they're safe to practice medicine. So that's what we've done to make sure we meet those goals of getting all those applications reviewed. So, and without that, we may have a lot of licenses that weren't going to be issued because of deficiencies, but I do believe the steps we've cut out now, just in light of the situation we're in, will help us get to that goal.
Mr. Watkins, did you have a question? And then I see Mr.
A comment. Well, first, want to congratulate Reggie, because he did some great work with maneuvering again the budget process. If you look at, we're looking at to have just managed this one fee request. We had to go 35 million into debt and spend 2.4 million. And I'm only saying that because to illustrate the actual cost that is involved in not making a decision, and to implore the legislature to stick with in granting this fee increase, because this board is in need of that fee increase to just operate the business of the board. My second question, and this is just small things, the e-blast that we send out, do you have like the open rates and, like the bounce rates for those emails? Because when we just say, we send out an e-blast, we assume that everybody's opening it and the information gets disseminated. Because I've heard it now twice where, if with the PTL, people feel like they didn't get this notice or that notice. And if we or just data managing that. See the open rates, we can say, the rate is 90%, so we know most of the people are getting the information. These are the things that obviously we need to manage when we start using electronic notification systems. Otherwise, we have to do the both. And I'd hate doing both because of the cost and the effort. But the notification to all the people, whether it's legislative changes, notice to doctors, we just have to know that we have a robust system to notify and be, in touch live with the stakeholders.
I know I do see a report from ISB when e-blast goes out to how many people it's been sent out to, and to be honest with you, I don't know if it includes the bounce rate or how many people reached, how many opened it, how many those. I don't think I have seen the statistics, but I wrote down your question, Mr. Watkins, and I'll get that response from ISB and pass that on to you or at the future
Mr.
meeting.
Brooks first, and then I'll come to you, Dr. Thorpe. Mr. Brooks?
Thank you, Madam President. Back to the PTL and processing times, is there a technological solution that could help, move this along? For example, when an applicant is submitting an application, if that application is incomplete, they should not be able to submit that application. And, 3 or 4 fields should come up and say, did you e-sign here? Did you fill in your diploma? Did you, get the certification notice in? Do we have that in place currently?
So, Mr. Brooks, there's no application that is complete at the submission point because there are certain documents that needs to come from the primary source from their school. The applicant cannot submit that on their own. And also their background check is missing at the time of submission. That comes from the DOJ. But I take your point. There should be a checklist of things that they are responsible for that must be complete before they submit. So I just want to say that, and I'll let Marina comment on it.
Yes, to answer your question, there are IT solutions, and we've been looking into a lot of them. Unfortunately, I'm not putting all the blame on our current system. It is very limited, but there are things, as Mr. Varghese mentioned, that we can do, and some of them we have done. One of the issues we've been seeing since the law change was, since the law changed, the law has been confusing for folks to figure out, where do I fall in this? What app should I be submitting? So we put into place questions at the beginning of the app to make sure that they were submitting the correct application, because that just further delays the process. By the time we review it, this is the wrong app. Now you have to submit, something else that maybe you didn't know you had to submit. So we have those questions up front that does stop them. If depending on how they answer the questions, you cannot proceed because this is the wrong application, go apply. So that's one of them, but there is more. Yes, there is definitely more changes we can do, more ways we can ask the questions in the system we have that will make them confirm, you have attached this, you have attached that. Right now it lists everything they can attach, but it's just a file with a name. So, it could be, you're hoping it's the document that's required, but and also to Mr. Varghese's point, they may not have everything at the time they apply, and that's okay because we're encouraging them to apply early. So what we're trying to focus on is making sure that those other entities that they rely on to submit those documents, that we're getting those in a more efficient way. So right now, we have to go to several different places to retrieve those documents and put them in our system. So for example, we're working with FSMB and they're going to be visiting our board in October to see how can we get information from FSMB to our system in a more efficient way. Because right now we have to retrieve things and that takes time. I have to log in, I have to download, I have to attach, I have to save. We want something that's more streamlined, some type of data transfer where it comes in automatically will save a lot of time. So there are IT solutions, some quicker than others. The ones that we can make in our current system, obviously quicker than something we might be working with FSMB that obviously requires their ability to do that as well. But I'm very confident we can get there, and we are making steps. It's definitely not as fast as we'd all like, but there have been improvements, but there are still more things we can do with our current system, and there's things we can do to partner with other entities to help get that information to us in a more efficient way. Just one more thing I want to mention, I think I may have mentioned a couple meetings ago, is we even have to kind of look outside of our current system into what other technology software is available that we can add on. For example, a system that allows applicants to see more information about their deficiencies. Breeze is pretty limited in what they get to see in Breeze on those deficiencies. So if another system that is connected to Breeze could offer that more detailed information and allow the applicant to authorize third parties to view that information, because we get a plethora of inquiries from programs asking what's going on with the application, which is confidential until the applicant authorizes them to, have access to that information. And this will also improve our communication. All those applicants calling, asking what's the status, all it says is pending, and that's not a lot of information on what's going on with your application. So that's something we really, really want to have, and hopefully we'll get, but and not to get too far off the point, but there is, of course, money involved, and we need to make sure we have the resources to get those IT solutions in place. And I think that's something we've been working on and will continue to try to strive for. But yes, in short, yes, there's more solutions that we can look at.
And just on that PTL point again, is my recollection correct that when the legislation was passed, the most recent legislation making the change that has impacted us in this way, when that was passed, the estimated fiscal impact to the board was 0?
Are you referring to the Jan 1, 2022?
Well, I think the most, if my recollection is correct, when that bill was analyzed for fiscal impact, the fiscal impact was 0, which is obviously far from accurate, right? I mean, I guess it's the point I'm trying to make, and if I'm wrong about that, let me know. But I think I'm correct. The point is, we need to think about how these things are actually going to impact us, right? Because when the legislature makes these very significant changes do affect real people and real applications, and sometimes we need more resources in order to be able to make these things possible. So, sorry, that's an editorial comment. But
we did actually identify a fiscal impact because we were authorized several positions, but they weren't effective until July 1. So because of the way the fiscal year goes, but when laws become usually enacted Jan 1, you can't get current year resources because the budgets, it's already through that process, unless it's in statute. That has, since the beginning of state process, been an issue of getting current year resources, and so there's that delay. And yes, 100% agree that that's something going forward. Every time there's a legislative change and we identify an increased workload, we have to make sure we get the resources to meet that workload demand when the demand is going to hit us.
Right, and I know there's some stuff in our Sunset Bill that is on exactly that point. Dr. Thorpe?
Thank you, Madam President. Well, first of all, I wanted to just say I just want to echo Mr. Watkins' comment about the benefit I'm just really pleased with the budgetary, the resource utilization of the Attorney General's office, and the significant decrease in cost there, which I think is part of the reason why the budget looks significantly better and why we've got potential surplus there. I realize it's just end of month reckoning, but then there's other charges that may come in late, but generally it certainly looks way better than it ever has before, at least in my time on the board. So I'm very pleased with that. And I also, it is a concern, obviously, that just shows the urgency of getting the fee increase so we can actually meet our obligations and pay back those loans. And I did want to make a comment on enforcement. I think there is it's obviously some significant improvement in trends in terms of time in investigation and time in, pending complaints, and there's a dramatic drop there as well, and I'm really grateful for that as well. I guess a couple of questions, and I realize that the challenges of licensing is that when you compare fiscal year 2021-22 and 22-23, we have 3,000, well, 2,500 more renewals that were issued in 2023 than in 2022, or 21-22, 22-23. Plus, the P&S applications have increased by about 800, or, well, maybe more than that. Yeah, 7,900 P&S applications received, and 8,600, that was for 21-22, 7,900 and 8,600 for this. So there's a significant increase in the number of applications in every category, P&S and also, physician and surgeon license, and for postgraduate training license, there's significant changes as well. So I realize that there's an increase in volume. What you mentioned, Ms. O'Connor, you mentioned that there is a high percentage of applications that are incomplete when they're received. Can you give me some idea? Number one, that's one question. What percentage are we talking about? Is it 99% or is it 70%?
So at the time of review. So when they are first received, we don't know if it's incomplete until we review it. And because of our processing times right now, that's a lot later. A lot more time goes by before we review it. So at the time of review, almost 75% are deficient.
So what are the 25% that are? So does that mean 25% are complete when they're reviewed?
Correct.
And how? I think we're talking about a very motivated population of people. These people have gone to medical school. They've gone through, there's a huge group of people that try to get into medical school. Usually it's about 10 applications for one person that gets into medical school, maybe more. So these are very motivated people. It's puzzling to me that somehow they can't fill out an application. These are pretty smart people. And what are the 25% doing right that the 75% are not doing? It would be helpful, I think, to identify that. And then, and then the other thing is, they're unintentional, I'm sure, but there is this perception that when applicants try to find out what's wrong with their application, they can't figure it out in some way or another, and they can't get through to anybody who will talk to them. I think those are significant concerns for program directors and for applicants, because they have no idea. And many of them are, I just see, and when I look at the chart on 6C-3, this is the workload report as of June 30, 2023, under agenda item 6C. If you look at physician and surgeon data, fiscal year 22-23, the total P&S applications received were 8,649. The initial reviews completed were 8,004. Licenses issued were 7,639. So there's 1,000 applications that have not been granted where applications were received. And these are people that are not going to be able to continue working in one way or another. Either they're not going to be able to get a job, or they're not going to be able to continue in their program. And it is real. Their program directors cut them off. They can't get paid. So, and this is 1,000 doctors that California needs. So, I know you understand all this better than any of the rest of us, but it's puzzling and frustrating to me to see this persistent, prolonged timeline that we just don't seem to be able to fix. And we keep hoping that, well, it's just going to go away eventually, or not going to go away, but it's going to fade out, or we're going to get enough staff, so it's puzzling to me why we can't get those applications filled out right the first time. And what are the 25% doing right that the other 75% need to know how to do?
Absolutely. It is very concerning that so many are deficient at the time of review because of how much time has gone by from the time they submitted it to the time we review it. Honestly, a lot of it isn't necessarily what the applicant's submitting in that app. So the applicant, everything they submit online, they're filling out questions, right? And they have to answer the questions in order to proceed. There's really only a few attachments they have to provide with that app. Most of the documentation needed when they transition from a PTL to a physician surgeon is coming from someone else. It's coming from FSMB, it's coming from the program that needs to fill out a training verification form. So that's where we're seeing a lot of the issues, is either the timing of getting that information, or the form is not filled out correctly. And so it's trying to figure out, okay, how can we revise this form to make it clearer, to make sure it's being filled out correctly. So what we're trying to do is more outreach to programs, program liaisons, and have guides to walk them through, this is how you complete this form, these are the common errors we see, because that's one of the worst things to happen, is we get that training verification form and we can't accept it because it wasn't signed by the current program director, or it shows dates that conflict with the dates provided by the applicant, and we don't know which dates are correct of their training. So that makes the whole process definitely slow down when you come across those things. And on the communication side, I just want to say, when we have deficiencies, we do communicate that to the applicant via email. So it's very detailed, and this is what we need, this is how you can submit it. But because it's coming from a third party, they have to then communicate that to the program and say, look, this is what they're asking for, this is how you need to submit it. And then they're relying on a third party to provide that. With the exam scores, because there's basically mainly two things needed from a PTL to physician and surgeon. It's passage of the U.S. Assembly Step 3 and then verification of training. Because of the short amount of time they have now to obtain going from a PTL to a physician surgeon's license, so if they're a U.S. or Canadian graduate, they only get the PTL for 15 months, they have to pass Step 3 and provide us those exam scores before that 15-month mark. It does not leave them much time. So a lot of the times they have everything in, and we're just waiting on that exam score to come in. So it's very difficult with the timing. They have to time it, make sure they're getting passing that exam, requesting the scores get to us timely, because that can hold them up.
So just kind of ask follow up on that, and that so how are I still didn't quite get that the 25% evidently got their scores, they figured out how to get their scores at the right time, and they got their verification of training, correct? So if we have a PTL in California, there's issues, there's other issues. We have trainees who are trained in other states and who want to either they went to medical school in another state and they're coming here for a PTL to a program, or they did 1 year in Michigan and they want to come to another program in California for whatever reason. But say we have somebody who went to medical school in California, and they need a PTL for California, or someone who is in a residency in California and has a PTL license, and they want to transition to a physician and surgeon license. My question is, first of all, I think the simplest one is, if they've got a PTL in California, it seems like that information should be it's just like a renewal practically. Why can't it just, I got my license renewed it was very simple. I went through online, filled out my application, clicked the button, I got my renewal within a few days. So why is it so complicated? I don't understand why it can't be that similar for PTL transitioning to physician and surgeon.
Once they have a PTL, we've already verified all their education. We don't need to verify that again. All we're talking about is verifying their training. So they have to have 12 or 24 months, depending on where they graduated medical school. So by the time when they're applying, if they're applying early, they may not have completed that training yet. We accept the training verification 30 days prior to completion of the training to give them some leeway there. So they're not running up against the deadline of, okay, I'm now this day done with my training, now get the form in. We actually give them 30 days in advance to submit that form. But that's all we need. We just need to verify they have that 12 or 24 months and that they pass the exam. Those are the main things. That's, again, I just have to say one caveat to that. There's many other things that could lead us to requiring additional information, unusual circumstances, issues during training, convictions, fingerprint results. So there's other factors. That's typically a small number, though. Not majority of the applicants fall in that category. So that's it. That's all we needed. I agree it should be simple. Docs was supposed to make that simpler to submit it. It has helped, but it's getting that form filled out correctly, which is what we want to focus on. Outreach to programs, guides, and online assistance so they can know, okay, what am I supposed to put here if it's not clear for whatever reason? Unfortunately, we have come across some programs that have been confused on how to fill out that form. We have been doing outreach events, but we also we're informed that a lot of programs have actually stopped doing orientations for their residents because ever since COVID, right? COVID, they kind of had to stop a lot of those in-person orientations, and a lot of programs haven't started those up, which those are super important opportunities for our board to go out and walk everyone through the process in person. Something, as many guides as we can put online, they still have to go, they got to look for the guide, they got to read it. And so we're hoping programs start to revamp those orientations for us to go out there and provide them that hands-on walking through, here's how you fill out this form, here's the information we need, here's what we're looking for, here's common mistakes. So we're trying to approach it, from an education standpoint and from an outreach standpoint, how can we help these folks complete these forms and get them in timely?
How confident are we? So we've talked a lot about notification by email, and just to Mr. Watkins' point earlier, do we have any statistics on the open rate and the bounce rate on those email communications? Are we pretty confident that we're getting the right emails for every trainee or every applicant?
Just anecdotally, I'm very confident that everybody gets at least one email when their application's reviewed with a list of all their deficiencies. What they don't get is when we get a form in, let's say it's a training verification form and it's completed correctly, we don't say we received your form, it's been accepted. What we do is we remove it as a deficiency. So if you log into their Breeze account, they'll no longer see that as a deficiency. So that's one communication I'm hoping we will have resources to improve upon. So right now, they're only notified when there's a new deficiency or an issue, like they did send in a training verification, but there's an issue with it, and then they're emailed again, we got this form, but here's the problem, here's what we need. So I'm very confident in the emails are going out. What we often see, though, is that they're putting email addresses, not their email address, but an email address to a liaison or a company they've hired, a consulting company to help them. And so I often talk to residents who are saying, I never got this, and I look up, okay, well, let me make sure we have the correct email address on file, and they're saying, well, that's not my email. And okay, well, this is the email that was provided on the application, so this is where those communications are going, and they ask us to update it. So it's, again, trying to stress these folks, make sure you keep your email address updated because that's the main form of communication. Yes, Breeze will show your deficiencies and they'll be removed as they're remediated, but the direct communication is via email.
Okay, can we move this conversation along? We will have an opportunity when we talk about our sunset bill, also to talk about some of the ideas we have for helping us with these processes. Because, again, these are, in some sense, unintended, in some sense, known consequences of making legislative changes, right, that have hard and fast deadlines in them. And I think that our staff have some ideas about things we can do to ameliorate the current issues. Dr. Blat, I know you wanted to.
Yeah, and I'll be brief because I'm looking forward to hearing more about this. But, I've been doing this for a long time, so I'm pretty familiar with what happens. And it seems that it's not just this particular thing, but when CURES came out and when the PICOS comes out and anything between the federal and the state governments to a program, I'm just wondering if we're really approaching this in a way that the accountability, right, the real accountability we can say stays with that particular trainee, but that accountability also rests with the programs. So that in a sense, we're trying to oversee thousands of people and multiple programs, and I don't see that as a way, as many outreaches as anybody wants to do, that you're going to get there. So in the sense that when someone gets a new vaccine, RSV is coming out, so CDC puts out webinars, and you can replay them, rather than having to make in-person. That would seem like, to address Dr. Thorpe's point, I think, if 75% of the people are doing it wrong, that's a problem. Secondly, the other piece that I'm aware of is that authorization. The accountability for determining a resident has met or has not met that 12 to 24 months lies distinctly on the program, its program coordinator, and its program director, and up to the DIOs. So in a sense, I think that it's going to be very important that we think of another way, which we'll address later, to get the outreach. I love that bounce rate, that whole thing. So I think the other piece is that people don't, as hard, I hate to say it, don't read their emails. But the point I want to ask today, right now, is how many people have gone without, have basically not been able to do a PEDS HEMONC, I'm just making it was in my head, fellowship in the state of California, or someone has to stop and they don't get their benefits and they don't get paid. Do we even know that number?
I don't have it off the top of my head, because we would only know it for our potentially we could pull that data for PTL holders, because then we actually know when their PTL expires and if they've been issued a license. But for physician surgeon applicants coming from out of state, we may not know when they were required to cease practice.
Okay. And just going down history lane, just Madam President, real quick, because I wasn't on the board at the time when this happened, what was the reason for this change? Can someone just give me the history, because I want to know why this happened in the first place?
Well, the most recent law change the board did not support. So the change on Jan 1, 2022, that changed the training requirement from 36 months to 12 or 24 was not supported by the board.
It was at the request of these same people who were struggling to process their applications now.
I see.
Yes.
Okay, thank you.
And to Marina's point, we did not support it. So, and we knew that there were going to be a variety of consequences, and we had other concerns as well.
Right.
So.
What was the reason for the legislation? That's what one piece. Do we have initially?
I mean, not to speak for people, but just what we've heard in all of the hearings that took place around that bill, and even during our sunset. The law before Jan 1, 2020 was the 12 or 24 month law. It was the 12 months of training, 24 months of training. And then it was changed to 36 on Jan 1, 2020, and they wanted to go back to that. They wanted to get their physician and surgeon's license earlier. There were a number of issues that had come up since Jan 1, 2020 regarding the PTL. Some of them had been resolved, getting DEA permits. They had, it was a new license type.
Moonlighting.
Moonlighting, yes.
Yes, and moonlighting was a big one, because under that law, Jan 1, 2020, residents were allowed to practice anywhere as it was authorized by their program. So it had to be part of their residency and approved by their program director in their file. So the question of moonlighting came up a lot. It was, well, can I go practice over here? Well, there's nothing in statute stopping you as long as you have approval from your program. But it was a new law. It was a new situation. It was difficult for folks. So I believe, the thought was if we go back to 12 or 24, we won't have that issue anymore.
And there were some other concerns from other organizations that are third-party payers. They didn't recognize a physician training license as a full and unrestricted license. So they also demanded that they've been issued a physician surgeon license after 1 year or 2 years. So there were a lot of other pressures, again, going back to the fact that board recognized 3-year training or 36-month training is what's the important thing for these trainees to complete, but again, that our opposition was not heard.
Okay, I'd like to move this conversation along. We still need to take public comments from those in the room and on the line. Are there any other comments or questions before I do that? Okay, let's go ahead and, are there any public comments in the room on the executive management reports? Yes, ma'am.
I don't want to sound critical, but you're highly underfunded. I have not been in any organization. I've worked as secretary to the treasurer of an oil company and different things of that type thing. And I've also worked in CAT scan and medical stuff too. But in the meantime, this group is highly underfunded. And I think we should be putting together petitions so that we can get the amount, excuse me, of staffing in here that is necessary in order for persons to be able to not be treated like secretaries almost in here. This makes no sense that you can't hire an outside agency to handle this type of situation as far as making sure that everybody can get their paperwork in. And there are so many companies that would apply to do the job for you. But like, it makes no sense to have 2 or 3 people like this trying to get some work done when they're doing work for thousands of people. It's, in my opinion, knuckleheaded. And then these amounts that you're talking about, as far as 6% and 4% going into investigation, that's zilch. I mean, and then 16.9 budget for the Attorney General's office. We're talking about the amounts of money that people pay for houses. I mean, seriously. My daughter's house would be like as much as some of these amounts that you're talking about in here. So it's insane to me that you have no money to work with. And that's what we need to do, is put together a petition so that we can get some funding into here and get more people working. And I think I'm getting excited, so I'm going to walk away.
Thank you. Any other public commenters in the room?
Put it close to my face. Hi, good morning. My name is Maria Ibarra Navarrete. I am from San Jose. I am a volunteer with Consumer Watchdog. This board failed my brother in 2022. My brother suffered from negligence from 2 doctors at 2 different facilities. He just wanted to come home and be with his family. My father was set to take care of him. That never happened. Jose had been receiving care in a long-term facility where his care was mismanaged to a point where he had to be transported to the emergency room. When my little brother arrived at the emergency room, a code sepsis was called. He needed his conservator and advocate to help him because he was disabled, but I was never informed that he was transferred to the ER. Although a code sepsis was called, the sepsis protocol was never implemented immediately. My brother walked away in search of a restroom. No one knew where he was. He was later found on the floor of the restroom, unconscious. To make matters worse, the doctor committed a medication error. When he used the medication during resuscitation, that was a contraindication with the medication my brother had been placed on for years. Instead, it caused the blockage of his vasopressors. It did the exact opposite. My little brother never had a chance. He died in that emergency room. Doctors must have every aspect ready in providing medical standard care for patients. That did not happen with my brother. That is considered below the standard of care. That is considered negligence. And it is this board's duty to protect the community this doctor is serving. I filed a death complaint with this board, yet my complaint was closed at the center complaint unit. This was a medication error, a never event. How could this board not investigate his death? I joined my fellow advocates in calling for all deaths to be investigated. Where is the human right of the public this board is supposed to protect? Other healthcare-related boards must follow the DCA guidelines and investigate all deaths. Why should doctors have other rules? My brother is no longer here with us, but I am here to fight for the human rights that he should have had. I am fighting for the rights of others, just like my brother, my family, and for your family as well. Medical negligence can happen to anyone. Thank you.
Thank you. Are there other commenters in the room on this agenda item? So are we going to, just a question, you all want to comment on the executive management reports, or do you want to comment on SB 815, which is coming up a little bit later? Or both? You can do.
6B.
Okay. And I'm assuming that the connectivity to the enforcement program is what we're talking about? Okay.
Sure. Can you hear me? Thanks. I brought a picture of Malachi. That's how I met him when I first met him. That's my firstborn grandbaby. I am Monique Himes, and I'm from Bakersfield, and I'm a volunteer with Consumer Watchdog. This board failed me in 2021. The enforcement process is incredibly difficult to navigate. As a family, we are devastated. We just watched our family and my infant grandson die needlessly. Sorry. If that isn't enough, then we are faced with an enforcement process that is so one-sided and definitely not in the interest of the loved one that died or the family left behind. My grandson lived for 18 hours. He was delivered by a postmortem C-section and was a live birth. Because my grandson Malachi suffered negligence with his mother, he was left alone to face negligence once again by the pediatric specialist who was assigned to his care following his birth, who was so negligent in his care that it is inexplainable. His birth, sorry, I'm repeating myself. When we tried to file the death complaint on behalf of my grandson, we were told not to bother. My grandson was a 5-pound baby boy who lived for 18 hours, and his brief life and death mattered. Whatever policies you have in place for complaints for babies needs to change. My grandson's death mattered, and we will continue to come before you until we can come together and adopt a policy that all deaths must be investigated. If the DCA policy is in place for nurses and the osteopath doctors, then it must be amended and required for doctors as well. Thank you.
Additional public comment?
Hello, my name is Kimberly Turbin, and the Medical Board of California failed me in 2015. I'm from Los Angeles, California, and I'm a volunteer with Consumer Watchdog. I have been participating in your meetings for a while, fighting for rights that I should have had when I filed my complaint. But just as importantly, I have been fighting for the rights of other Californians, especially for mothers in the maternal mortality fight. I filed my complaint, and it did make it to investigation, but I had no other contact with the board after that. I had no idea where my complaint went, where it went to. And if that was just going to be allowed to run its statute like some of the other maternal mortality. Wait, excuse me, I missed a spot. I have been fighting for the rights of other Californians, especially for the mothers in the maternal mortality fight. I filed my complaint, and it did make it to investigation, but I had no other contact with the board after that. I had no idea where my complaint went and if it was just going to be allowed to run a statute, like some of the other maternal mortality, maternal health cases. In my case, I suffered from medical battery by my obstetrician. He insisted on doing an episiotomy with no consent and no medical reason. I asked him not to, and I continued to plead with him to let me push and not to cut me. But he went ahead and cut me anyway. He slashed my vagina 12 times in a horrific rage, from one end all the way to the other. The difference in my complaint was that the entire battery was caught on videotape during the traditional filming of the birth of my baby by my family member. I was injured, and I'm still injured today. I suffer in pain, and I have 3 medical vaginal conditions that there is no cure for. I looked for help, but no one would help me. So I decided to put my birth video on YouTube. My birth went viral on the internet. No one should have to do this to move this board to take action on a complaint. Our team will continue to come to these meetings and fights for rights of the process of these changes that need to be made. Thank you.
Additional comment in the room? Okay, we've got one public commenter on the line.
We do have one caller online.
Okay, please proceed.
Arthur's daughter. You may go ahead.
Thank you. I've been on hold now for an hour and 21 minutes. And that's for a call-in for the last segment. And the reason why I've had to wait this long is because there's a delay between the computer presentation and the call-in presentation, and you don't allow enough time for the call to process through. And I've been waiting, as I said, over an hour and 20 minutes.
Ms. Arthur's daughter, which item would you like to comment on?
Said about not being able to hear is because normally when you do this type of a phone-in communication, you have to use a corded telephone, a landline, not a cell phone or a cordless phone. That hinders the clear transmission. That's why there's problems with it. By not allowing people the time to dial in again, their phones are going to go dead in the meantime because most phones only have a limited amount of time when they're in use. Or, in this case, we had no way of knowing that we had to set up a landline so that we could communicate with you. So, as to my comments from the last time, agenda item 5, like the one caller that was there, we have had problems with communication for years with the board. Even when you do get some direct communication and it sounds like you're being listened to, etc., there's not any follow-through. I've been in this process since 2014. I finally got a hold of somebody, and it sounded like they were listening, and then, nothing came of it. Even when they talked about the external communications, it wasn't even documented. And the information I had supplied was not acknowledged at all. So, it's wonderful to use words to say that you're listening to us and being empathetic, but when push comes to shove, we don't see anything come from it. Now, you talk about these email blasts going out. Again, it's one thing to throw that stuff out there, but you can bring the horse to water, but you can't make them drink. There has to be some receipt acknowledgement from the providers who receive this information that they received it. It has to be by the provider, not by their staff. If people are to be held responsible for guidelines, etc., or providing a quality of care, you have to have some contractual element to it, and that's missing in how this is being sent out. So again, it goes back to what Mr. said
Ms.
about
Arthur's daughter, can you please wrap up your comments?
Yes. Anyway, so with that, then yeah. Anyway, with the next segment coming up, with all of the agenda items on number 9, is there going to be a comment after each one or not? And if we have to wait, it would seem that if people are having to join this by telephone, that you maybe take those people first before the people in the
Right, Ms. Arthur's daughter, we're going to take public comments.
because otherwise we're going to not be able to communicate at all. So that, or at least break it up so that there's a chance to comment.
Okay, we've gone over
Very
the
difficult, moving the goalposts all the time.
Can we
and
stop
trying to
this
keep
caller?
up with this while I'm listening in one ear on the computer and one ear on the phone. It's next to impossible. And it's hard for you folks there too.
C-team,
So
can
it's
we
almost
cut this off so I can address it?
That's how bad this has gone. But we do need that communication, though, to be really, really energetically pursued at the board by the members. And I would like to have a chance to talk to Dr. Thorpe about some of the stuff that I sent over, because I don't see it.
Okay, thank you. Thank you for your public comment. We're going to continue to take comment the way we traditionally do for all these various items. Are there any further public comments on the phone? Okay, we have one more. Let's go to that comment.
Xavier De Leon, you may go ahead.
Hi, can you guys hear me?
Yes, please proceed.
Okay, perfect. Hi, my name is Xavier De Leon, and I'm a local advocate here with Consumer Watchdog. The reason that I'm calling is because I believe that it's time to take action and make a change in the enforcement process, especially for babies. We have one of the highest infant mortality rates in the Central Valley, and in my story, we were failed by the board in 2021. We were approached by this board before we ever filed a complaint. An investigator came to question us and went about it as if we had did something wrong. The main problem in this is that 2 people had died in this story, yet the investigator did not focus on my son Malachi's death. When we tried to file a complaint, we were told it wasn't necessary because the investigator wanted to group my son with his mother, as if he wasn't harmed by 3 doctors and lived a brief life of 18 hours. Malachi had rights. When we filed an accusation against the doctor, Malachi was only mentioned in the accusation of having been born and died. Although he lived for 18 hours, he had rights. We will never address our infant mortality crisis as long as this board continues to ignore the rights for babies to have their deaths investigated. Lastly, I believe all death complaints should be investigated, especially if other healthcare-related boards must send their death complaints to investigation. Thank you.
Thank you for your public comment. Are there other commenters on the line? Okay, we'll bring it back to the board. Are there any final comments or questions from board members about agenda item 6, executive management reports? All right, seeing none, we are going to move on to agenda item 7, and then following agenda item 7, we are going to break for lunch. So agenda item 7 is updates from external stakeholders. Do we have an update from the Department of Consumer Affairs? Welcome.
Hello and good afternoon, President Lawson, Vice President Hawkins, Executive Director Varghese, and members of the board. I'm Melissa Geer, Deputy Director for Board and Bureau Relations, and I appreciate the opportunity to share the Department of Consumer Affairs update this afternoon. Before I get started, I would like to take a moment to congratulate and welcome David Lee to the board, as well as congratulate TJ Watkins and Drs. Thorpe and Mahmood on their recent reappointment to the board. In addition, I would like to congratulate Mr. Varghese on his appointment as the new executive director. Thank you all for your service and your commitment to protect California's consumers. I have several updates and reminders to share, starting with an update on DCA's DEI efforts. On May 12, 2023, DCA's DEI Steering Committee held its quarterly meeting in person and elected Chairperson Yafana Lamar, who currently serves as the department's tribal liaison and is the Chief of Legislation for the Contractors State License Board, and a Vice Chairperson, Paul Sanchez, who is the Executive Officer of the Speech, Language Pathology, and Audiology Board. The committee discussed training, strategic planning, and DEI activities through the end of the calendar year. Providing employees access to DEI training is a priority for the DEI Steering Committee. In June, DCA began offering 3 DEI courses, which are available to all DCA employees. The courses are Understanding the Value of DEI in the Workplace, How to Decode Our Unconscious Bias, and Unleash the Power of Generational Differences. The response from employees to participate in these new DEI learning opportunities has been significant, with high registration and attendance numbers. The DEI Steering Committee is pleased to announce that outside consultant Dr. Bernard Gibson will provide in-person DEI training to DCA managers, supervisors, and leaders in October. In addition, Dr. Gibson will provide virtual training to board members on the morning of October 9th, 2023. Dr. Gibson has 20 years corporate experience managing teams and training employees in business effectiveness. Dr. Gibson also has extensive teaching experience at various colleges, including serving as adjunct faculty since 2006 at the University of Massachusetts for the School of Business and Professional Studies. Information on registering for the virtual event has been sent out. For those that cannot make the training portion will be recorded and be available later. I look forward to updating you in the months ahead on the progress of the DEI Steering Committee. Also, to further the department's efforts to reach Californians we serve, DCA will request boards translate any press releases they issue into Spanish. California's top non-English language spoken is Spanish, and establishing a standard of translating releases into both English and Spanish will enhance the reach of information released. Boards are also encouraged to evaluate any additional languages outside of Spanish that may serve their audiences. For additional information, please contact BBR. Next, as many of you may know, the changes to the Bagley-Keene Open Meeting Act that allowed board members to not have to notice their meeting location or meet on an ADA accessible location expired on July 1st. As a result, public meetings are subject to the traditional pre-COVID requirements for open meetings. DCA boards should be prepared to conduct public meetings compliant with the Bagley-Keene Open Meeting Act. This includes whether a meeting is held at a single centralized location or at multiple teleconference locations. Each physical meeting location will need to be identified in the meeting public notices and agendas. Board members must attend meetings in person at the noticed meeting locations. All noticed meeting locations, including locations where a single board member will be, must be ADA accessible, have an agenda posted, and be open to the public. The public will be permitted to attend meetings at any noticed meeting location. Additionally, members of the public need to be able to hear the meeting and participate in public comment from each location. DCA has a Bagley-Keene Open Meeting Act guide available and has provided your executive director with a list of available meeting locations throughout the state. Please reach out to Board and Bureau Relations with any questions or concerns. DCA is committed to helping the boards to make this a smooth transition. SB 544, which may allow for some meetings to be held without notice, seeing the location of the board meeting, thus allowing remote virtual meetings, is still going through the legislative process, and the department's Division of Legislative Affairs is working with stakeholders and providing updates to the boards and bureaus on the status of this bill. In addition, you may be aware that DCA has been working to implement AB 07 by Assemblymember Salas, 2021, and effective July 1st, DCA boards, unless otherwise exempt, are required to grant temporary licensure to the spouse or domestic partner of an active duty military member stationed in California if the spouse or domestic partner holds a license in another state with the same scope of practice as the profession in California for which they would like to practice. DCA's Office of Information Services and Communications Division have been working to support the implementation. All boards were recently provided an outreach toolkit to help share the message of this new benefit for military spouses. DCA has also updated its military resources website to reflect this new benefit as well. Next up is an update on two important projects that we are proud to share with you. The first being the Enlighten Enforcement Project, and the second, the Data Governance Project. The department is continuing work on its Enlighten Enforcement Project that is being piloted by the Dental Board of California. The Dental Board has walked through their intake, complaint processing, citation, and investigation processes. One more walkthrough session will cover the discipline and probation processes. The goal is for staff to walk through the processes with subject matter experts so improvements and efficiencies can be found for the Dental Board that can be carried over to other boards as well. The project also aims to learn best practices between boards and to standardize procedures for all boards. The final benefit will also be a template for policies and procedures related to the enforcement process for all boards to utilize. DCA is continuing its efforts to improve its reports regarding licensing and enforcement activities. The director recently led multiple work group meetings beginning in late April through early July with staff from each board and bureau to update the data metrics reported in DCA's annual report. DCA's goal is to ensure consistency between the report data and the annual report, DCA's data portal, and board sunset reports. Future meetings are expected in August and ongoing to help build new reports or modify existing ones to provide these new metrics for next year's annual report. Additionally, DCA held a meeting on July 17th with all boards and bureaus to review guidance on how boards can compile and report data to the department for inclusion in this year's upcoming annual report. Before I close, the following reminders you may find helpful as you begin to prepare for the fall. First, board members who have been appointed and reappointed cannot begin their service or perform any official functions without first taking the oath of office. Unless otherwise provided, the oath may be taken before any officer authorized to administer oath. Board members should contact their executive officer, or in this case, executive director, to arrange taking the office of oath. Board members will be required to complete the documents listed on the Board Member Appointment Checklist, or HR5, and return them to the Office of Human Resources no less than 30 days after their appointment or reappointment. Duties cannot be assumed and appointments cannot be processed until documents are received and are accurately completed. Incomplete packets may delay per diem payments and or travel reimbursements due to the member. Second, there are 2 DCA-wide mandatory trainings for 2023. This includes sexual harassment prevention training and information security awareness. All DCA employees and appointees, including board members, will need to complete the sexual harassment prevention training this year. Board members must take the 2-hour supervisory training. This training is required every odd-numbered year and is online, self-paced, in approximately 2 hours. Both the sexual harassment prevention training is available on the department's learning management system. If board members need assistance in accessing LMS and the training, please reach out to the board and bureau relations. Third, please keep in mind that all state travel arrangements must be made through DCA's authorized travel agency, Cal Travel Store, or Concur. When traveling by air on official state business, all board members and staff must use the most economical fares possible. If the flight is changed, there may be additional charges. Flight changes for personal convenience are not permitted or justified, and the traveler is responsible for any associated charges. Please contact BBR if you have any travel questions. Also, please note the Attorney General issued a press release adding 3 new states to California's restricted travel list with staggered effective dates in 2023 and 2024. As follows: Wyoming, travel restricted effective July 14th, 2023. Missouri, travel restricted effective August 28th, 2023. And Nebraska, travel restricted effective October 1st, 2023. If you have any questions, please reach out to your executive director for additional information. Lastly, board members must complete board member orientation orientation or BMONT within 1 year of their appointment or reappointment. On October 10th, 2023, BMONT will be offered virtually. This will be the last meeting of the year. Members can register for this training via LMS. And as I close, thank you again for this opportunity. This concludes my updates, and I welcome any questions from the board.
Thank you very much. I think we're going to hear all of our external stakeholder updates, and then we'll take questions at the end. We have update from HQIU.
Good afternoon. I am Chief Kathleen Nichols with the Division of Investigation, and this is Stephanie Whitley, Deputy Chief for the Division of Investigation's Health Quality Investigation Unit. It is our pleasure to provide the board an update on the Health Quality Investigation Unit, also known as HQIU. The Division of Investigation has some facilities projects I would like to share with you that will reduce costs for the board. Maximizing the efficiencies of telework, we are shrinking square footage as leases come up for renewal. For example, our San Jose office is moving in September 2023 to another location in San Jose, and we were able to reduce the square footage needed since we implemented shared workstations for staff instead of having dedicated workstations for each employee. This has resulted in a decrease in rent of approximately $5,000 per month, which is a $60,000 annual reduction in lease costs for one field office. We also have 2 ongoing projects to merge DFI Investigation and Enforcement Unit IEU offices with existing HQIU offices. The Lakewood IEU office will merge with Cerritos HQIU, and the Hayward IEU office will merge with Concord HQIU. The IEU program will pay for their portion of space, creating a cost savings for HQIU and MBC. It is anticipated once completed, these mergers could save an additional $50,000 annually per office. We are looking at merging additional offices in the future so we can maximize the cost savings we can achieve for the board.
Currently, HQIU has 25 investigator vacancies, which is a 30% investigator vacancy rate. Although the vacancies have increased, we have recently promoted 3 investigators to supervising investigator positions, and their knowledge is critical in filling those key management roles. We currently have 22 candidates in background, 6 of which are in their final psychological and medical portion, and hope to have a final clearance soon. In addition, we have 2 candidates who have received clearance with upcoming start dates for September. We are continuing to screen new applications for each office on a repetitive 30-day cycle so we can quickly fill the remaining vacancies. At the end of June, we had the pleasure in attending the graduation ceremony for 3 new HQIU investigators from the South Bay Regional Post Basic Police Academy. The Academy staff expressed how impressed they were with our investigators, specifically noting their strong work ethic, their tenacity, and their ability as leaders to work as a team with their peers. In July, the division's training unit provided time tracking training to all HQIU investigative staff, focusing on the importance of accuracy for cost recovery purposes. The training was well received by staff. We continue to visit HQIU field offices to meet with all of our investigators about their work experience and our goals for case aging and quality. The investigators continue to look forward to having our remaining vacancies filled so it will reduce the caseloads per investigator, which will assist them in the ultimate goal of reaching case aging goals. We continue to make progress on our pending workload in cases over a year, as evidenced in our updated graph in the board item 7B. We continue to hold weekly meetings with board staff, in addition to sending an automated monthly report with all case status updates. We look forward to our continued meetings with the board staff, and this concludes our update. we'd be happy to answer any questions, but I just heard the president say we'll answer after.
Thank you very much.
Thank you.
All right, we're going to go to a budget update from the Office of Attorney General, and I think we are doing that via the screen. Am I right? They're joining by Teams. Okay.
Okay, go ahead.
Good afternoon, board members. I am pleased to introduce you to Ashley Harp and Maria Salerio, Staff Services Managers 3 and 2 respectively, from the Division of Operations, Attorney General's Office, Department of Justice. They are both here to answer fiscal-related questions that the board members may have of the Attorney General's Office. At the last medical board meeting, well, by way of background, Maria Salerio and Ashley Harp last appeared on August 19, 2021 to field your questions regarding the board's legal services revolving fund, the so-called LSRF, and Attorney General billing rates. And prior to that, in 2020, Chris Ryan, DOJ Director of Operations, appeared before this board setting to answer fiscal-related questions. And at the last medical board meeting in May 2023, the executive director included an Attorney General budget report and a copy of frequently asked fiscal questions, and you can find those in the agenda item 6B, pages 17 through 24. And at today's meeting, the executive director has included and discussed additional information in agenda item 6A, enforcement program summary, at pages 16 through 24. It's a privilege and honor to be involved in the protection of the health and safety of California consumers. And at this time, I will turn the microphone back to the board for your questions, and also invite Ms. Harp and Ms. Alario to answer your fiscal-related questions. Thank you.
Great. So it sounds like we're going to bring this back to the board for questions. We can ask them of any of the presenters, but we do have the folks from the AG's office on the line if you have budget-related questions. No questions. All right, could we bring the lights back up so we can go to public comment then? Okay, are there any comments from anybody in the room? Please come on up.
The very thing I've been saying from the time I walked in here.
Ma'am, can you just wait till you get up to the microphone?
The very thing that I've been saying from the time that I started commenting is that it looked like you needed more staff. And someone comes up and says there are 30 spaces that are empty? I mean, somewhere in here there has to be a grant writer, and I've written grants for all kinds of people. But somebody in here needs to be able to write to agencies, to public entities, to the big pharma. Somebody needs to be able to write to get some more funding in here so that you can actually do something for the concerns of the constituents. Because right now we got the doctors, they're mad because they're not getting their things put through, but like the constituents need to be taken care of too. So it would seem to me that a part of the thing that you're going to be doing when you're scaling is to make sure you get a team in that writes to get you funded, because it makes no sense in the world that there are 30 positions empty in anything. Not even out there in the fields do they have 30 positions empty picking cabbages. Peace and out.
Thank you. Additional comments on the the stakeholder reports, please.
Again, my name is Denise Johnson. I live in Tracy, and I need that? Okay. And I'm a volunteer with Consumer Watchdog. My son, Richard, was diagnosed, and you failed him in 2015. He passed away in 2009, April 15th. You sent your letter to me May 29th, 2015. Richard was diagnosed with brain cancer and an inoperable brain tumor. He was given the treatment he needed. He fought hard, and he beat his cancer. He survived brain cancer, only to die from a treatable hospital-acquired infection. Richard's doctor decided on his own to stop providing treatment for my son without consulting him or us, his family. After Richard died, I filed a complaint with this board. Actually, I filed 4. Your enforcement staff, they called. However, the person on the other side somehow found Richard's death, tragic death, comical, and I hung up on him. Talk about kicking a mom when she's down. That did it. Talk about, let me tell you, there is nothing funny about your child dying. Whether mother, father, whether it's an accident or needless, because of a doctor decides to stop treating. Your enforcement process is cruel. As advocates, we have been working hard to show you what needs to be changed to give us the same rights in the enforcement process. I stand with my fellow advocates that all deaths must be investigated. Although it went nowhere for me, I still stand and believe that. The treatment I received from your enforcement staff should never happen to another mom or dad. You need to take a good look at your enforcement staff. Maybe perhaps retrain them how to be compassionate and work with the grieving family. Thank you.
Thank you. Are there additional public comments on agenda item 7, updates from external stakeholders?
Hello again. I am Tracy Dominguez, and I am from Bakersfield, and a volunteer with Consumer Watchdog. This board failed me in 2021. Your enforcement process is not for the weak. The problem is the grieving parent is at the weakest state of mind after losing a child. I filed a complaint on behalf of my daughter, and I tried to file a complaint on behalf of my grandson, Malachi. The problem was that the board sent an investigator to my home without even notifying me. I wasn't ready to be questioned by an investigator. She made me feel like I was under investigation for the death of my daughter. Not the doctor who had been harming mothers and babies for 32 years, which was a well-kept secret, supported by this board. I thought losing my daughter was the hardest thing that I had to ever endure. But your enforcement process and the investigation process was almost just as painful. I truly believe if we had not ran a campaign, along with Michelle and Consumer Watchdog, that the board would have given that doctor probation once again. After all, Celeste Ortiz's family was promised that they would go before administrative law judge for revocation hearing, but at the end, he was given probation for Celeste's death. A horrendous death was the same doctor yanked out her placenta and hemorrhaged right before him to the death 3 years before my daughter and grandson's death. The deaths must stop. There was another young woman who at the same doctor yanked out her placenta, but she lived to talk about it. This happened before Celeste's death. There was many opportunities to stop this doctor. My complaints went unanswered. The only way that we can break this cycle is to make a change. And like any other healthcare related board, that requires that all quality of care deaths must be investigated, really, and especially repeat offenders. This will help stop the cycle. Demi would be here if the board had stopped this doctor. Malachi would be here if the board would have stopped this doctor. Thank you.
Thank you. Additional comments on the stakeholder reports?
I'm Naomi Sweat. I'm from San Diego. My hometown here is Bakersfield, and I'm a volunteer for Consumer Watchdogs. The board is in the process of failing my sister, like other Bakersfield maternal death families. Your investigator came to us. We hadn't filed a complaint. We were not ready for an interview. My little sister had only died 2 weeks before your investigator showed up at our door. The baby was still in the hospital. Our family was interviewed by an investigator, the end. We never heard back from the board. We called the investigator and called again and again, and no response from the board. We never received a letter from the board issuing a control number or a case number, nothing. Meanwhile, the repeat offender doctor who didn't come to the hospital to find out why my sister was in so much pain, even though she went to the hospital twice that day, he is still practicing. The doctor that just kept issuing pain medication without coming to her bedside to attempt to discover the source of her pain is still practicing. I say repeat offender doctor because he was on probation when my sister died. He was on probation for harming other women and sexual misconduct. You recently filed another accusation against his license. But what about Sabrina? What about her death at 23 years old? Does your staff just ignore calls and contacts until we eventually quit trying to close the case? We need answers. Thank you.
Thank you. Additional public comment?
Yes, good morning. Excuse me. My name is Larcenia Taylor. I'm from Bakersfield, and I'm a volunteer with Consumer Watchdog. The board failed me, actually my husband, in 2021. When my dear husband James died, I was devastated, and I am still devastated. My husband James had an ailment that was easily treated before by another doctor in a local hospital, where he had the unfortunate fate of getting the wrong emergency room doctor in charge of his care that day. I later found out that not only did my dear husband die under his care, but a 3-year-old child was also harmed by this same doctor. My husband died from medication error, an error that never should have happened. The medication was Zofran. You doctors look that up and see if cardiac patients are supposed to have that medication. So I filed a complaint with this board. I never made it past the central complaint unit. My husband's complaint was closed with no interview and no input from me. How do you investigate complaints for, how do you not investigate complaints for medication and errors? My only hope is that when the mother of the child that was harmed by the same doctor files her complaint, that you will bring my husband's complaint to combine with hers. I am a woman of faith, but this enforcement process challenges my faith. I support my fellow advocates in calling on the board to investigate all quality of care death complaints. How many deaths and injuries have to occur before you investigate a physician? Investigate all deaths and you will begin to address the repeat offender issue to this board. And I'd like to ask you all one question. all those who have a spouse or a partner, if they were not here tomorrow, how would your life be? Just think about that. Doctors know better, they can do better, and with the board and Miss Michelle helping, hopefully we'll do better combined, working together to save lives. Remember, these are people's lives. They're not just numbers, they have families, and thank you.
Thank you. Additional public comment in the room on stakeholder reports?
Hello again. I'm Alka Airy from San Francisco, and I wanted to share a bit more about how the medical board's enforcement process failed me and my sister. I filed a complaint in 2019, and within 6 weeks, my complaint was dismissed without any action, without reviewing any of the records I had in my possession. The additional medical records that were held by the transplant organizations, none of it was reviewed. And I would have expected the medical board to do more because it involved a transplant program. And the patients that go through our transplant hospitals across the country, and especially in Northern California, are incredibly vulnerable. I don't know if you're aware of this, but in Northern California, we have only 2 lung transplant hospitals in the entire northern region of the state. If my sister had lived in New York City, she would have had access to 5 top transplant programs. She would have been concurrently listed at multiple hospitals. But she didn't have that choice because she lived in San Francisco, and there were only 2 hospitals. And as a result of a delayed diagnosis of heart failure and pulmonary hypertension, which are both incredibly easy to diagnose in a non-invasive way through an echocardiogram, that delayed diagnosis mattered because it meant she could only go to one hospital. It removed the choice of the other. And when that hospital failed to list her and failed to answer her, how in the world did she get to this condition? She had no choice. She had to trust the doctors who were standing in front of her, lying to her. And when she went into a second medically induced coma, and this time got placed on VA ECMO, I had to make these choices. And that's when I discovered that the doctors didn't disclose that she had heparin-induced thrombocytopenia, which is very easy to diagnose. They literally hid a test result from me. And if my sister's primary care doctor hadn't stepped forward and come to the ICU and asked, where is this test result? It's missing in the records, we wouldn't have known that she even had this condition. They didn't do anything. But after my sister's death, got all the records, I got all the transplant-related records. I thought I was going to have a chance to put forward to the medical board, we have a serious problem, especially in Northern California. These transplant patients have no choice in care. And yet this medical board didn't do anything. And it breaks my heart. I am lucky that I'm healthy, but it breaks my heart when I meet other patients in Northern California who need a lung transplant, and they don't know the games that their only hope of a hospital plays in manipulating transplant scores, in delaying diagnoses, and if they are involved with any part of the care, if they make a mistake, they won't come forward. These are the types of problems that I would have hoped the medical board would have addressed, and I do think that a simple interview of either me or the physicians, I understand that never even occurred, that could have made a difference. But the medical board failed me, and if we don't do anything more about it, I think that more especially vulnerable patients are going to suffer, and we have to change that. Thank you.
Additional commenters in the room? Okay, do we have any? We have 2 on the phone. All right, these are comments on external stakeholder reports. Item 7.
Thank you. Our first comment comes from Monty Goddard.
Hello. Good afternoon. It's Monty Goddard once again. I do have a very short question. After years of familiarity with the board's infamous death certificate project, as the Department of Consumer Affairs Health Quality Investigation Unit staff read the medical board's updated opioid prescribing guidelines. Thank you.
Thank you for your comment. Are there additional comments on the phone? Okay, we have one more.
Yes. Our next comment comes from Rosie Arthur's daughter. Your line is open.
Thank you. Just a moment here. I was surprised when I heard the comment about the restricted travel. That was not in the materials for the presentation. So I had to do a quick search here to find out what that was about. And that's about something called AB 887. And this is a law that was enacted in 2015. And at no time since 2015 has the medical board had that in any of their documents. And what this involves is restricted travel now to 26 states. So how can you do your jobs that might on occasion involve traveling to half of the country for something that was not noticed? You're reminded you can't do it. 26 states you cannot travel to. Why? Because laws have been made to protect minor female children from having biological males come into their locker rooms against their best interest. They have no choice. This is shocking. I mean, I guess that's why you didn't put it in any of your previous newsletters, never talked about it at a meeting, and certainly didn't put it in the agenda items. Maybe you need to have an agenda item of how can you do your job if you might be having to investigate something in one of these other 26 states that protect legally the rights of biologically female children that at one point in time would have been pedophilia at another time and in another state to try to superimpose somebody else's rights here, in theory, over somebody else who's in reality having to face that. I'm just appalled. I'm sorry. That's my comment. Somebody else should have noticed that this law was around before reminding you that you can't travel to certain 3 states when it's 26 states. Thank you. Bye-bye.
Thank you for your public comment. Are there additional comments on the line? Okay, we'll bring it back to the board. Are there any comments, questions on any of the external stakeholder reports from board members? Dr. Hawkins?
So the questions for Ms. Whitley and Nichols, HQIU. So it involved questions about investigators and about the trend of the pending investigations. Comments about the trajectory, what are you attributing that to? And regarding the investigators, you always seem to have a large number of investigators, space vacancies. Can you tell us a little bit about how you're doing with the new hires, how you're retaining them? What's your strategy for keeping new investigators in the system?
Yes. With respect to the vacancies, we did see a small uptick in vacancies, but as we mentioned in our report, we did promote 3 investigators to supervisor positions, so that created some additional vacancies. We are also still having people leave for higher paying jobs. So, we have all these people in background, we hire them, it's a revolving door of people who leave to make more money. So that continues to be an issue. The contract negotiations are going on right now, so I'm optimistic that we will see hopefully some retention differentials in the new contract that would help kind of fix that problem. And with respect to the pending caseload, we are receiving less complaints, so that's what's been able to help us. You know, you'll see we're still making, you know, small decreases in case aging, our pending caseloads coming down, but that's with 25 investigator vacancies. That's equivalent of 3 field offices vacant. So it's very taxing on our existing staff, who are working extremely hard. You know, we're reassigning cases, rotating cases, but we are making progress. We do have 22 people in background for those 25 positions, so we are very much staying on top of the hiring, getting these candidates in place. We have ads posted, continual ads. We're out at, you know, career fairs, going to other, you know, events, trying to recruit other law enforcement agencies, candidates from other law enforcement agencies. And then just to address the prior question, all HQRU investigators were sent the new updated pain guidelines. So those have been distributed to every investigator, every medical consultant, and everybody has them.
So are you losing senior investigators as well as new investigators?
It's kind of a steady stream of both. You know, we have 2 people that are in background right now to leave for LA Unified School Police, that they're going to receive a huge raise. We had somebody else just resign because they wanted to take care of their family. We had somebody else resign because they moved out of state, you know. So those things are continually happening. So I think the pay is a big issue. Hopefully one that this contract will resolve. It's also a workload issue. As we've discussed before, these cases are very complex. And the investigators now, they have a caseload in the upper 20s. We have a couple investigators over 30 cases apiece. That number should probably be around 15. So those are all things as we're competing for candidates, even within Unit 7, if everyone gets paid the same, but other programs have a smaller workload, it's harder for us to retain investigators.
Thank you.
Additional questions or comments from board members? Okay, seeing none. That concludes that item. We are going to break for lunch now. I'm going to ask that we return at 1:30, if that makes sense, 35 minutes. All right, we are going to be on recess until 1:30. Thanks, everyone. On that note, I think we're ready to reconvene. It's 1:37 p.m. and the Medical Board of California is back in session. The next item on our agenda is Agenda Item 8, discussion and possible action on proposed 2024 board meeting dates. Mr. Verghese, are you going to lead us in this discussion?
I'll be glad to, Madam President. So in your board notebook, Agenda Item 8, there are 2 options for your consideration. And the staff would like to go with fix and board approve and adopt one of the options, and option 2 is the preferred option that we would like to recommend. That would give us enough legislative timeline to work with in between the bills and introduced, and so we can bring it back to the board. So that option is preferred, but then again, it's a board's pleasure.
I move we accept option 2.
Second. My only concern is that option 2, they're all before long holidays with travel, unless, you know, because it's right before Thanksgiving, and so are we going to travel with the Thanksgiving rush and then Memorial Day? But, you know, as long as it's, as we all said, as long as we have plenty of notice, we can make it work. But I just sort of want to have that be a consideration. Right.
I won't be here for option 2 because of the holiday travel.
Okay, so let's talk about that then. Sorry, I'm still pulling it back up because I got signed out of SharePoint.
Option 1 also falls during a holiday week in February.
Option 1.
Option
President's Day.
Yeah, the President's Day. Just following President's Day.
Okay, I mean, is there, Any more discussion? Did you want to move option 2?
Well, I just wanted to ask Mr. Verghese, why is option 2 preferable to the staff?
This is because of bills filing deadlines and legislative bills filing deadlines and such. But like I said, we can make option A work if that'll work for majority of the members, because that's also important to have a quorum.
Yeah, I mean, the quorum issue is pretty important. We were worried about it for this
Well,
meeting.
I'll withdraw my motion then, unless
You're withdrawing
the
it
seconder is willing to withdraw it.
I'll make either one work.
I'll second it.
Oh, yeah, option 2. This is for 2024. And the November 20th and 2021st are the week before the Thanksgiving holiday? Yeah. Yeah, that would be fine for me, but I'm, yeah. Right. Hopefully by November of 2024, we have a full board, which we don't currently, although I've been working with the governor's office on the appointments office on that. Okay. What's the preference, team? Option 2, if that's the board staff's preference?
I'll move option 2 if that
Okay.
works for the group.
That's fine with me. Do we have a second?
Sure.
Okay. I think I need to take public comments.
Do we have to vote on board meeting?
Mr. Brooks, don't forget to use the microphone, please.
I don't know if we need to vote on board
I don't think you have to
meeting dates.
vote
It's on
on-
here as an action item.
It's administrative.
Yeah, I think as long as your staff is clear on which date, and then for the sake of things, you could also call for public comment.
Okay. I don't think we need to vote on this, to Mr. Brooks's point.
Yeah.
Yes?
Obviously, either is fine, but microphone, please. Oh, sorry. Either is, yeah, it's all right. The either is fine. Is it possible to take a straw poll which one people prefer? Because we're all sort of, yeah, whatever.
I mean, we can. I don't see any, I mean, I don't prefer either at this point. Does anyone have how about this? Does anyone have a very strong preference as to A or, 1 or 2? No. Okay, we're good. So, okay, let's just open it up for public comment. Are there any commenters who wish to have input on our board meeting dates? Anyone in the room? Anyone on the line? Okay, we're good. Our board meeting dates are option 2.
Thank you very much. This will help staff tremendously in finding locations ahead of time, so thank you.
Great. Could I ask that Janelle email calendar holds to all of us for these? I think that would be hugely helpful if staff could do that for us.
Yes.
And get the dates, rather than leave it up to our individual responsibility to get these dates on our calendar.
Why do you look at me, Madam President?
All right, okay. On my notes, it says consider a lunch break. We've already done that, so we are going to move on to agenda item 9, discussion and possible action on legislation. I will say, we have a fair number of our advocates who I believe are out of the room for lunch, and I think they may be very interested in SB 815. Aaron, I'm wondering if we could take the others first, and then Janelle, if you could maybe, or someone could let them know we're moving into legislation so that they can come back. I think that would be great. But if we take the others first, I think that might be best for our agenda. Is that workable?
That works for me, Madam President.
Okay, so which one should we start on then?
Well, if I may, I have some introductory comments to start out with, and then, but I will definitely keep to the order that you've asked.
Okay, thank you. Go for it.
Great. Good afternoon, board members. I regret that circumstances prevent me from joining you all in person, but nice to be with you in whatever ways possible. If you look at the green and blue color-coded tracker chart, it indicates that there are only 2 bills that the staff are recommending for discussion. The first is the Sunset Bill, and the other is SB 544, which relates to holding remote board meetings. Before we get to those two, I wanted to point out to the members and those observing the meeting that there were two bills amended yesterday that are on the agenda. The first is AB 1369 and the other is AB 1707. And last night, updated analyses were emailed to the board members and posted online to the board's website. With respect to AB 1369, the amendments update the definitions surrounding the patients and physicians who would be eligible for the licensure exemption, the telehealth licensure exemption that is, in the bill, but they do not resolve the board's opposition, which is rooted in the view that licensure is a foundational and a vital form of consumer protection. And the AB 1707 amendments were technical in nature. And so therefore, since neither sets of amendments were contrary to the board's previously adopted positions, the staff do not recommend discussing those bills. So unless there are any questions about those two or any other bill on the agenda, I'm happy to go to SB 544.
Great. Any questions there? Okay. Seeing none, Aaron, we can go to SB 544.
Great. Thank you. This bill facilitates the use of online-only meetings by a state body like this board, which is subject to the Bagley-Keene Open Meeting Act. The board adopted a support position earlier in this year, and since then, the bill was amended to require that a majority of the board members be present in the same physical location for at least half of the board's meetings each year. The other amendment made was to sunset this new authority in 2 years, effective January 1, 2026. So we basically get a trial run at this for a 2-year period. And the bill is not limited to the board. This applies to many, many state boards and commissions. Staff do recommend that the board maintain its support position. We did just want to put this before the board in case of any questions or concerns that may arise. If the board desires to maintain their support position, then no action is required. And I'm happy to answer any questions, Madam President.
Thank you. Are there any questions on this bill? Does anyone on the board wish to make any changes to our position? All right. Looks like it's staying as is.
Okay, very good. I don't know if you wish to go to public comments or move on to the next item.
I think we can move on to SB 815. So
okay,
we've got a group back in the room. I wanted to make sure that was at least a possibility, so I think we're ready to go on that.
Okay, very good. My notes. So following the prior board meeting, SB 815 was substantially amended. There is quite a bit of detail involved, which is described in the analysis and displayed in the current version of the bill. One thing I wanted to quickly point out is that so far there have not been any changes to the fee amount authorized in the bill since we last met. Given the current status of the bill, however, there are certain other amendments that staff recommend that the board adopt and reaffirm in an updated position of support if amended. In addition to the amendments that we are seeking specific to SB 815, there are a few additional licensing-related changes that we wish to bring to the board's attention that are expected to go into separate legislation as they are time-sensitive. There are 3 items detailed on pages 6 and 7 of the analysis that are intended to help ensure that those transitioning out of and entering into postgraduate training programs have additional flexibility and clarity to meet their respective deadlines. The first would be to extend the expiration date for PTLs that expire between June 1 of this year and the end of calendar year 2023, to extend those out until March 31st of 2024. This law change will help ensure that otherwise qualified doctors transitioning to a physician and surgeon license don't face a lapse in their ability to practice. As previously discussed in the meeting, we are marshaling additional staff resources to process these applications quickly. but this statutory change will provide an additional measure of insurance, if you will, to help support these providers. The second is to change the current 90-day application deadline to a 180-day application deadline for physician and surgeon applicants who have some out-of-state training and are joining a training program here in California. This change would align with a separate 180-day deadline for PTL applicants to obtain their license. The third is to make a clarifying change to when the 180-day deadline for PTL applicants commences. Currently, statute says that the time frame starts on their enrollment date. It would be clearer and also consistent with the board's current practice to amend that law so that it states the 180-day time frame commences when they begin their training program. We wish to bring these to the board's attention and provide the opportunity to discuss them if you wished. But these three proposals are not intended to be included in the board's sunset bill. The administration and legislature are working to adopt a separate bill so that way these proposed changes can take effect more quickly. The other recommendations discussed in the analysis for board approval also, they include eliminating an outdated requirement that PTL holders show 4 months of postgraduate training in general medicine in order to obtain their physician and surgeon license. Staff also suggests the board approve amendment requests to delay the implementation of conducting complainant interviews until we have had time to recruit and train new staff, and various technical amendments that are discussed in the analysis. Finally, with respect to the burden of proof language in the bill, staff are recommending that we request the legislature to either adopt the preponderance standard for all disciplinary action or to retain the clear and convincing standard under current law. As discussed in prior board meetings, although the board's position is support if amended, it is important for the bill to win approval from the legislature and signature from the governor. Therefore, even if all the board's requests are not met, staff in consultation with the board's president and vice president plan to continue advocating for approval of this bill. Also mentioned earlier, there's an item that may lead to a change in the board's leadership to be taken up later today. And given the time previously committed by the current president and vice president, I suggest that the board authorize the staff to continue to work closely with Ms. Lawson and Dr. Hawkins on any final details and possible changes to the bill as the legislature wraps up their work soon. Therefore, at the appropriate time, I would suggest the following motion. That the board adopt a new support if amended position to include the staff recommendations on the final page of the analysis, direct staff to work with any appropriate stakeholders to support the urgent enactment of the 3 identified PTL changes, and to direct staff to continue collaboration with Ms. Lawson and Dr. Hawkins on SB 815 until the bill is approved by the governor. I recognize I've just said a lot there, Madam President, so I'm happy to answer any questions.
Thanks, Aaron. Are there any questions from board members? Dr. Thorpe.
So, Mr. Bone, thank you very much for your work, and also to Ms. Lawson and Dr. Hawkins for their diligence in trying to shepherd this through the legislature. It's a very, a daunting task. I had a question about the evidentiary standards, and this seems to me to be very, open, if you will. I was very comfortable with the previous approach to evidentiary standards with preponderance of evidence, except for evidence for areas of revocation. I can't remember what else. There was 2. Anyway, it was the clear and convincing was going to be applied to. I believe it was for revocation of licensure, and there was another one. I can't remember what it was, but because I think that is, if you're going to take somebody's license, it needs to be very clear that they. It needs to be a very clear thing that you're going to, and there needs to be clear and convincing evidence that they are not appropriate to practice in the state of California. to just say, well, then preponderance of standards for everything makes me very uncomfortable. We've been operating with clear and convincing. What, you said either adopt preponderance standard for all or retain the existing clear and convincing standard that's currently in present law. And if, given the gravity of this situation, I would personally ask the board to support clear and convincing. If it's going to be one or the other, then I would say, then I would prefer the board support the existing language.
So if I may, Dr. Thorpe, so the board, my understanding, based on our sunset report that I think we approved last December in that time frame, was that the board supported the preponderance standard for all cases. And Aaron, correct me if I'm wrong, but that I believe was our position.
You are not wrong.
Yes. Okay. So I am right, I guess then. I am not wrong.
You're right. You're right.
So my recollection was correct. So that's the board's current position. That's not what that's not how the bill currently reads, because the bill was drafted by someone who had a differing point of view. So it was drafted with this bifurcated standard of review. And what I believe Mr. Bone's requesting of us now is to clarify that we either prefer what we asked for in the first place, which was preponderance, or we prefer things to stay as is, but that the bifurcated standard of review is not something our staff believes to be in the best interests of the board or California consumers.
Can I respond to that? I mean, my only point is, so I think previously when I'm not sure I remember exactly, but I believe that when the initial preponderance vote came up, I believe I recused myself from that vote.
I believe you disagreed with that.
Yeah, and that's why I disagreed, is because I think that the preponderance of evidence standard for revocation is really inappropriate.
Right.
I think clear and convincing specifically for revocation is preponderance of evidence is too lax a standard.
Right. So
that's my personal.
Yeah, I mean, my recollection again is that was your point of view back in December. Is there a will of the board to change our previous position and eliminate that request for preponderance? Mr. Brooks?
Me personally, I'd like to hear more from the other board members, especially the doctors on the board, to see how much what type of effect that would have. Because we'd also want to have an effect on new recruits, people coming into the profession.
Right.
And so I don't know if that's a red herring. I don't know if that's the reality. I have no idea whatsoever. So I'd love to hear from the physicians on the board on their opinion.
Yeah. So, but I want to make it clear that to the extent we are making a change, the preponderance standard is in our sunset report. That was our request to the legislature. So we will be making a revision to our previous request if we delete it. That's not to say we cannot do that, but our position that's in writing to the legislature is a request for the preponderance standard. Okay. Mr. Watkins, did you want to speak?
Yeah, I think we should stick with the standard with the original proposal as in December. And I think the foundation for that was, we just sat through the whole morning listening to all the issues that has to do with, cases not moving forward, cases getting closed, and then, outcomes not being, which was something that is, I'm passionate about. And the board decided that preponderance of the evidence would be a sufficient remedy to that. And I still think that, most of the public feels that that's a remedy. And I think it is a possible remedy too.
Yeah, I mean, just as a reminder, I believe it's 41 other states use the preponderance standard, so we're the outlier in using clear and convincing. Having been involved in these conversations and being familiar with the text of the bill, there is some confusion in terms of how we would implement a bifurcated standard, given how our processes work. So I do have a concern that if we're not going to sort of get exactly what we want, that we not create a situation where we cause more problems for our enforcement process, right? I certainly don't want to cause problems or that would result in delays or that would result in lawsuits against the board to the extent we impose discipline under bifurcated standards. So that's what I believe board staff is trying to address here, and just give Dr. Hawkins and myself some flexibility to continue the conversation and negotiation, if you will, as this continues to advance to a final bill. Are there others that want to address Mr. Brooks' question? Others with strong feelings?
Madam President, I don't have particularly strong feelings. I think what would be instructive to all of us, and because this is the legal aspect of medicine, is preponderance of evidence is something is more likely than not to have occurred, right? And then if you could state for us the clear and convincing, what exactly you see as a lawyer and as our board president, what do you see as the two? But I'm still supporting the preponderance of evidence. But if you could explain that, because
so I'm not sure I'm the best person to explain the two standards to us. I'd rather have our lawyer or Aaron, who's been working with this too. Yeah.
Yeah, actually, Mr. Bone probably is. Since I don't have a direct quote, I would say, since you've worked in the legislation in detail, if you have that handy, the distinction would be the best.
Yeah,
hot potato.
I know it comes from a Supreme Court case, Edinger, which I don't have in front of me, but essentially the standard I think keeps with the name, that rather than preponderance, is it just more likely that it occurred, than something occurred than it did not occur. The evidence for clear and convincing must be that. It must be clear and convincing to a reasonable person. That's my understanding of the difference. And it is some amount less than the beyond a reasonable doubt standard, which is that for criminal matters.
That's right. I'm glad you stated it that way, because essentially it's the gradation where clear and convincing is stronger. So in practical terms, when your two panels are seeing disciplinary cases, those ALJs have weighed in, or any case that would go to an ALJ, for example, that's how they're balancing the evidence in front of them. It's essentially a higher standard versus a preponderance of the evidence is still more likely that it occurred.
Thank you.
So, currently, why this would really fundamentally change the enforcement part of how the board operates, which I really think needs that level of attention, is that currently the HQIU, they investigate these cases to meet that clear and convincing standard. And if they are already doing that, that's in place. To meet then the preponderance of the evidence, which is a lower standard, I think we would, because many of the cases, we just can't prove it to that high standard. And the question then is that is way too high, because we only do 4% of our cases that ends up in discipline anyway. And those are the numbers that we see that needs to improve in order for, everyone to not be happy, but feel represented, because half of the room don't feel represented by us. And this will certainly move that forward.
Yeah, so, the board's current position is that we'd prefer a change to preponderance. And I think the additional authority, if you will, that is being requested is that we be able to, communicate that, our sort of dissatisfaction with the way the current legislation is written.
I think my only comment to Mr. Brooks is that, as a physician, I practice medicine according to what I know, what I'm supposed to do. I don't practice with, am I doing clear and convincing, or is this I think that's a legal standard. I think, Dr. Thorpe is, a license is something very difficult. There's a property interest, and that's why we afford due process. And so ultimately, whether or not the standard is utilized, it's in a judicial arena where the experts will tell us this is a per bond. So I think in terms of looking at it that way, it won't affect the actual practitioners on a daily basis, but it's more of a legal issue, as Mr. Watkins says, that when it comes to the adjudication of issues, that's the standard we have to put up with.
Yeah. No, and I think that's a good analysis, and I appreciate that. My first rule when I do anything or make a vote is do no harm, right? And I always want to make sure that I'm understanding and listening to kind of the angles that I may not see, what's my blind side. TJ was saying, I think it's spot on. So many of these cases that we hear over and over again would have never been brought to this board because of the level, the standard that it has to reach in order to get to this board. And so I think this change is a very positive change. I just wanted to make sure we were thoughtful and continuing with this recommendation moving forward. So I appreciate the time.
Yeah, I would just like to make one more comment. I understand where the sentiment of the board is here, but I just think it's important to recognize that one of the comments Mr. Brooks alluded to was the issue of perception. How is this? What is the practice of medicine perceived to be like in California? California is a very, in terms of attracting physicians to California, there is a perception that California is a very highly litigious state. There's a perception that it's, that the cost to practice versus the cost of living is very discriminate, meaning it's hard to attract doctors to California for that reason. They don't get paid enough more to adjust for the cost of living, so many of them go other places, other states. And this would just be one more of the number of things that are against California to be able to recruit doctors. And if it's perceived that in California you're more likely to get disciplined because the standard of evidence is lower or has been lowered, I think that's not going to be good for attracting. One of the important thing about protecting the public is to make sure that we have excellently trained physicians in California to bring the standard of medicine and the standard of care to keep it current. And not having enough doctors in California is not in the interest of the public.
Dr. Mahmood, let's focus on whether or not we want to change our
I personally think that we are getting off the focus talking about is California attracting other doctors or not. That is not our problem. Our basic duty is to provide protection and safety to public and do everything possible so they are enough represented, and we are representative for them, for people who have grievances, people who are being harmed in some way, and give the due process. And as TJ said too, that number of complaints passing through are not really to the number where we should be seeing. If some doctor want to make a choice to live in California, standards and facts are there. We are not here to discuss that, whether we are giving them enough money or enough privileges or less chances to get sued. Those are not our thing. I think that will be a very, very wrong message, and I strongly resent to that.
Okay, let me ask this question a different way. Does anybody want to change the board's current position? And are we okay with the alternative that if the board is unsuccessful in securing this, that we want to continue our current standard? Okay. That's one of the 6 recommendations of our staff. Are there other of the recommendations that we want to discuss? Okay, I'm going to open it up for public comment. Are there commenters in the room who wish to speak on?
Madam President?
Yes?
Do we need a motion first?
Perhaps.
I'd like to move that we adopt Mr. Bone's recommendations.
Thank you.
As described.
Okay, we have a motion and a second. We will now open it up for public comment. Are there commenters in the room who wish to comment on SB 815 or SB 544. Are there, please just make your way forward.
I'll try not to cry this time. I am Monique. I'm from Bakersfield and a volunteer with Consumer Watchdog. I've grown as an advocate, having participated in your meetings and testified at sunset reviews and legislative hearings. When my grandson Malachi first died, I could not understand how such egregious negligence could occur and take the life of a precious baby boy. I began to understand why once I became an active advocate. It pained me when I later learned that a doctor that was responsible for his care and his mother's care was a 32-year-old repeat offender doctor. Then to later learn that the pediatric specialist that oversaw his care after his birth was responsible for the death of 2 other babies. We are here for change. We appreciate you working with us to ensure that some of our priorities made it to the sunset bill, including the required interview. The required interview before a complaint is closed would have given us the ability to fight for the right for my grandson to have his complaint accepted and for his death to be investigated. We need the required interview to be implemented immediately. We cannot wait until 6 months after you require staff and then train staff. You wouldn't ask doctors to wait 6 months to a year after a licensing program. It would be a priority for you to implement it. Use the existing staff you have until you acquire the staff you need. We have also rallied for the patient impact statement, but the changes being made and proposed changes to the patient impact statement is not what we advocated for. These changes will remove the impact statement from the disciplinary package based on the decision of the medical expert, who is a doctor. Our intention was for the impact statement to be included in the package for all decision makers to review, so not only the doctor, but the person who died is also a primary focus of the final disciplinary documentation. We can fix this. We recommend that you ask to request the patient impact statement after the complaint has been forwarded to the Attorney General's office. Thank you.
Thank you. Additional comments?
Kathleen Nichols, Chief with the Division of Investigation. I'm just commenting on the burden of proof issue, and I appreciate the board's position about wanting the lesser burden for all the cases. My concern with the approach, if you can't get that, is to go back to the way things were, is that's just going to create more of a problem. There's so many serious cases not getting filed because we can't meet that higher burden of proof. And from an investigative standpoint, the bifurcation is not going to affect us and how we investigate the case. We're going to investigate the case the same. The issue is going to be at the end when it's reviewed by the Attorney General's office, is there enough evidence to file? So I think it's important, because the problem is if you take that position, they're just going to throw it out of the bill. This was a gift that the language is in there at all. And although, of course, I would want preponderance for all cases like the board does, I don't think that you should recommend to take it out, because even a bifurcation is better than nothing. And there's a lot of cases that just are not getting filed because they're not meeting that clear and convincing. So I would urge the board to reconsider that. Thank you.
Thank you.
Hello, my name is Kimberly Turbin, and I'm from Los Angeles and a volunteer with Consumer Watchdog. I just want to say that we appreciate the effort and work you have put into ensuring the priorities that are important to us, that they were included in this bill. We have been working on our own support, the fee increase and the required interview, and our other priorities. We do have concerns. We are concerned about the all or nothing approach with the burden of proof. Although we agree with you and we also wanted a lowering of the burden of proof for all actions, we do not want to lose the possibility of lowering the burden of proof for suspensions and revocations. It is not ideal. but it is some movement in the right direction. We are concerned about the changes and recommended changes to the patient impact statement. The purpose of the patient impact statement was for it to accompany the disciplinary documentation that the decision makers will see when a decision is made on the case. We see an issue with removing our patient impact statement, depending on whether the medical experts find it relevant or not. We recommend that you ask for the patient impact statement to be requested once the complaint has gone to the Attorney General's office. We also do not support the request for a delay in implementing the required interview program until 6 months after you acquire and train new staff. People are dying now, and our complaints are being dismissed now. We need to figure out how to implement the process with the existing staff until you acquire additional staff. Thank you.
Thank you. Additional comments?
I'm Naomi Sweat, and this is my first sunset review with the board, and I have participated in advocating for our priorities in the board meetings, and I participate in all our actions to support your fee increase in our priorities. One of our main priorities is in 2 steps. The required interview is very important to me because it would resolve my current issues with the board. 2 weeks after my sister died from maternal negligence, an investigator came to our home to interview my family. It had just only been 2 weeks. The interview happened and that was it. We never heard from the board again. We don't have a control number or a case number because we never received a letter from you. We have called numerous times and left messages with no response back. If we had a required interview, we would at least know the status of the investigation and to the license of the physician who was linked to my little sister Sabrina De La Rosa's death. The patient income statement is a second step within our priorities. It has changed and we don't support the changes. We understand that the physician should have due process, but what about the process for my family and other families? The patient impact statement should not be given to the doctor's lawyer. They should not be an option of whether the patient impact statement is viewed by the medical expert or not. We're asking for the patient impact statement to be requested once the case reaches the Deputy Attorney General as it was originally considered. That resolves the issue. The initial patient impact statement that we have rallied for is losing its impact, and we do not accept the staff's recommendation. Thank you.
Good afternoon, board members. My name is Denise Johnson. I'm from Tracy and I volunteer with Consumer Watchdog. Sunset Review and this bill has given us the opportunity to speak with you and dig deeper into issues that will give us some due process, but also improve your enforcement process. I have participated in our team's actions to support the fee increase that this board desperately needs to continue to operate. We will continue to support that fee increase in actions until this bill goes to the governor's desk. Our required interview before a quality of care before a quality of care complaint is still in the bill. We are pleased and we will continue to do what we can to protect it. Our concern is with one of the other priorities, the patient impact statement. Please understand, the doctor walks into this process with a lawyer. We walk into this process alone and generally kept out of the process. We have to fight for our own protections. We have a hard time believing that the doctor's lawyers will review our impact statements and decide that they are valid. We see hundreds of these impact statements thrown out as the lawyers ask for them to be removed. We are concerned with staff's recommendation that our impact statement does not need to go to the medical expert. If the medical expert does not view them as necessary, I'm not completely buying the process that less impact statements are viewed by medical experts, then less of our statements will be given to the doctor's lawyers. If our impact statement does not go to the evidence of the case to the medical expert, then what happens to our impact statement? Is it dropped into the black hole? I have a hard time believing that someone in enforcement will pick that impact statement back up and reinsert it back into this enforcement process so it moves forward with the evidence. We don't approve of these changes. We are supporting your fee increase. Now is the time to continue to support our priorities and revise the bill so the patient and impact statement is requested once the case goes to the Attorney General and as it originally considered. This is where our impact statement should be received. Thank you.
Thank you. Additional public comment in the room? Could we, by the way, bring the lights back up to...
Thank you very kindly. We are making complaints today and are in support of there being more funding to both departments, very much so, because there's not enough people to handle the expert witness area of it. But we're also requesting that a part of the expert activity should be DNA testing, because, and that can be done by outside agencies. And especially if there's any question as to the authenticity of organs that are in, when we're looking at, in some instances, in some places, hospitals, they're doing red harvesting here already. And also, in a call to the DOJ, it resulted in a comment from one of your representatives in citing that we wanted to find out about DNA testing before a body goes to the morgue after it's been out and paid to be in refrigeration for over a year. But then this person said that sounded like a legal matter and basically just flipped it off. And when someone says it sounds like a legal matter, it's like, well, are you a legal expert to come up with the idea that that's a legal matter when we're thinking there's criminality involved? Okay, so we're just asking that if a matter is turned over to the medical board and there's any question about the authenticity of the body parts that's in the person, well, it seems that the Department of Justice or someone would be in charge of making sure that all the organs match, since some of them are extremely reduced and some of them look like they have been waterlogged. It looks like the person was in the desert in a rainforest in the ocean. You know, it makes no sense. And we do have in our family a pathologist, a physiologist, and some other persons who have looked at the information, but they're not in the position, they're in other states to do anything about this. But in this state, we need to do something about it here, because if they're red harvesting in the, where my husband is concerned, but then they may be doing it for somebody else or to somebody else. And I've talked to other veterans that have gone in, one going in to get a detox, and they took out 3 of his internal organs and didn't clean his colon. And another one who went to for testicular cancer, and they literally took off the wrong testicle. You know, all kinds of strange things happening. So, and in my husband's case, they lost the brain for over 5 weeks and said that it was missing because one person was out sick at the VA. So we kind of want to be at the point where we can get testing of those parts, since they came in looking like he was, they were from different people, plus they couldn't find his brain. So I appreciate you taking the time with us, but you might want to speak to your people on the phone and tell them, don't just bounce us off and say, that sounds like a legal matter, because it doesn't sound like a legal matter to us. It sounds like a criminal matter. And thank you for your time. God bless you.
Thank you. Are there additional commenters in the room?
Again, let's see. Okay. Hey, I'm Tracy Dominguez, and I am a volunteer with Consumer Watchdog. We have spent a lot of time on this bill. Our team, not only just testifying at every medical board pushing for the priorities in this bill, but we also work together on actions to support the fee increase that you desperately need to keep this board going. As you know, the required interview is one of our priorities, and it is very important to us. We do not support your wish to delay the implementation of the program by 6 months or more in order to hire and train a staff. We can't wait any longer. You need to use the existing staff you have until you hire a trained one for the program. And the burden of proof. We all have worked too hard and very, very stressful working hard for this, lowering the burden of proof. We agree with you that lowering the burden of proof is needed for all disciplinary actions, but we can't give up what we have. Please keep the lowering of burden of proof as it is in the bill. It is a small start, but it's better than nothing. And you know we will get nothing if we agree with the staff recommendation. And the impact statement. The patient's impact statement would have helped me and would have helped Celeste Ortiz's family and other families. You are making this so complicated. We recommend that you revise the recommendation and request the patient impact statement from us once the complaint is in the Attorney General's office, and have the DAG request the patient impact statement. And hopefully this will help solve some of the problems. Thank you.
Thank you. Are there additional comments in the room?
Hello again. I'm Elka Airy. I'm from San Francisco, volunteer with Consumer Watchdog as well. I was actually very inspired when I saw the board put forward many reforms which my fellow advocates had pushed for as well. I thought it was a step in the right direction. I know it was very challenging to get done, but I was encouraged that you were hearing us and that the board heard everybody, injured patients and their families, and recognized that we have concerns. Our concerns are legitimate, and they deserve to be heard. And when you look at the issue of the patient impact statement or the required interview in instances of catastrophic injury or death, it's about creating a dialogue. It's about creating an open channel of communication that currently lacks in the current enforcement process. We don't have an opportunity to speak. There's only so much you can convey in a letter. There's only so much, I was given a fax number, so there's only so much you can fax. It's limiting. I think it was only about 20 pages I was able to get faxed through. But having that mandatory interview, having the opportunity to provide an impact statement makes all the difference, and it doesn't cost much money. And I was a little concerned when I overheard lawmakers talk about SB 815 at the last committee hearing and their concern around the fee increase, the increase of basically $20 extra per month, and how that was just an absurd amount for any physician to assume. And that caught me off guard. I didn't expect it, because if the board does not have the budget, how are you going to provide oversight? And the reforms that you've put forth and advocated for in the Sunset Bill won't get done until there's adequate funding. And Mr. Verghese brought up a very good point about the loans and how we need the funds in SB 815 to achieve the reforms. So it seems like there's a disconnect between what some members of the board want and what lawmakers want, and it does a disservice to patients and families and the people of California. And in my personal view, California is a leader for civil rights, for progressive rights and laws, but I don't see it coming from the medical board. And I hope that all of you will help lawmakers understand the need to get adequate funding for the board but also to remember that we have to give a place to patients and their families to give them a voice, because a letter or a fax is not going to cut it. Sometimes you just have to have a conversation, and that's all we're asking for, and I hope you'll keep that in consideration. Thank you.
Thank you. Are there additional commenters in the room?
Good afternoon. I'm Michelle Montserrat Ramos, and I'm with Consumer Watchdog. I also would like to thank the board for listening to our team and supporting and incorporating some of our priorities into the Sunset Bill. As you know, we're a team of survivors. Whether we survived our egregious lifelong harm ourselves or whether we are the ones who have survived the greatest tragedies of our lives, the loss of our family members, or in my case, losing Lloyd Montserrat. When you make these decisions, and I like to think we're heading in this direction, I would like us to get to a point where you would consider us, the public, a stakeholder in this process as well, because we are. We are the ones that are filing these complaints. We're the ones that are submitting these complaints. We're the ones that had to submit them because we lost our arms or our legs, or we lost our family member, our daughter, our son, our grandchild, the love of our life. We are just as much an equal stakeholder in this process as the healthcare providers are. And I really wish you would see it that way. All of these advocates that come forward to speak to you, it's a great sacrifice, not just in time, not just financially, but emotionally and spiritually in every which way, to come before you and offer recommendations and offer options for change, to try to meet you halfway. And we were getting to that point, but it's a little concerning when so many people, which includes all of you and board staff as well, put so much effort into this bill and the consideration of going backwards to clear and convincing evidence across the board. As you know, and as the people have talked about today, we are a part of this process, and we go into this process alone. We don't get to walk in with a lawyer. We don't get to come in with a medical expert. We don't have any of those options, and that's why we've come before you over and over and over with other options, the required interview, the patient impact statement, something that would give us a voice, something that would give us some rights in the process. So when you make these decisions, I hope you keep that in mind, that we're equal stakeholders in this process too. Thank you.
Thank you, Michelle. Other commenters in the room?
Hi, good afternoon. My name is Teresa Ibarra. I am from San Jose, and I am here because my family's complaint was closed without being fully investigated. The required interview and patient impact statement is incredibly important for me, and it will be an important establishment for future families that have not yet faced tragedies that we have and will need to file complaints in the future. The required interview would have kept my death complaint open. When my family submitted our complaint, the toxicology report was not available at that time. If a required interview was in place, we would have been able to provide additional information that we received from my brother's toxicology report that would support the medication error. The death complaint I filed with this board was dismissed because the board was unable to meet the burden of proof required to pursue action against the doctor. The staff is asking the board to propose to either adopt the preponderance of the evidence standard for all disciplinary actions or keep the existing language, the clear and convincing. At the sunset review, when this bill was discussed, a member of the board addressed that all advocates, that this board hears them and wants them to work in collaboration and care for the safety of the public. I ask that board member and this board to ask themselves, what would you do if the disabled person that died at the ER bathroom, like my brother, the high percentage of women and babies that have died due to maternal negligence, or individuals that have lost their lives due to medical or medication errors, was your mother, father, or child? Errors happen every day, and there must be a scale that does not tilt more to one side but provide equal rights to everyone. So with those of you that did side with the preponderance of it, with preponderance of the evidence, I stand with you. I do think that this is definitely a standard that needs to be looked at, and we should not look at it from a business perspective regarding how many doctors want to come and work in California. As you heard, there are 41 other states that do have this preponderance of the evidence standard. And I also like to say that I too look at California as being a leading state, so we should also join them. Thank you.
Thank you. Other commenters in the room?
Hello, good afternoon. My name is Abril Dozal, and I'm here to speak on behalf of the resident physicians who called in earlier and the 10,000 resident physicians represented by SEIU-CIR, the Committee of Interns and Residents. We represent 88% of the resident physicians in the state, and they are overwhelmingly asking the board to create a transparent turnaround time for issuing licenses, remove the mental health question from licensing applications, and streamline the application process. We were one of the groups that pushed to reduce the PTL from 36 months to 12 months in 2021. That is because our members' ability to practice was severely limited when the PTL was created in 2020, which we believe was the real root cause of the backlogs we're seeing today. In addition to increasing the total number of applications the board had to process, with the original PTL, resident physicians weren't able to prescribe medication, they couldn't sign insurance paperwork, and they couldn't moonlight. Moonlighting is crucial for residents trying to make ends meet, and their financial stress impacts patients because they have to split their focus between providing care and figuring out how to pay rent. Also, because of the healthcare worker shortage, some communities rely on moonlighting residents, and the PTL exacerbated that shortage. We understand that the board is severely understaffed and underfunded, and we support resolving the delays in a way that does not impact resident physicians. CIR is supportive of expanding the PTL validity back to 36 months as long as residents who want to transition to the PNS after 12 months can do so, and that their applications are processed within a reasonable time. Residents should not have to wait 6 months to get their license after submitting a complete application. This wait risks their careers and delays access to care for the communities they serve. CIR is advocating for a 60 working day timeline for processing applications. In case that the board is unable to meet this, DCA should be notified so they can deploy a strike team to help address the backlog. Residents also shouldn't be afraid to seek mental health care. Because license applications ask about treatment, residents are told to use pseudonyms and pay out of pocket if they go to therapy. Resident wellness is patient wellness, and these questions do not encourage a healthy physician workforce. Lastly, CIR is encouraged to hear that the board is looking into ways to make the application process more efficient. We are happy to support streamlining the PTL and to the PNS transition in whatever way we can. In closing, I present a petition with 46 pages of signatures from resident physicians across the state calling for the board to accept CIR's amendments to SB 815. Please let me know who can receive this petition on behalf of the board. Thank you for your time.
Hand that over to Janelle. She'll get it to us. Thank you. Sorry. Additional comments in the room?
Hello, everyone. My name is Lucas Evanson, speaking on behalf of the California Medical Association. CMA would like to underscore the comments made by SEIU related to the PTL. CMA has been contacted by residents, programs, physician faculty, and even legislators who are extremely concerned about the potential limit in access to care should these residents not remain licensed. So CMA supports the board staff recommendation to extend the expiration of their PTL to March and give residents with 1 year of postgraduate training 180 days to acquire their license instead of 90. CMA is working with the coalition to try and add further flexibility and predictability to SB 815 for residents by requiring the board to process applications within a specific amount of time. We are proposing 60 days. And allowing the board to extend deadlines when a resident is applying for a PTL or physician and surgeon's license if they can provide a valid leave. This language has been shared with board staff, and we hope that we can work with the board and staff to reach an agreement. Thank you.
Thank you. Additional commenters in the room? Okay, Stina.
We have 3 on the phone, but Gloria wanted to make a comment as well.
Okay. Ms. Castro?
Yes, good afternoon. This is responsive to the current agenda item only. The completed investigations that are received here in the health quality enforcement section are received from the Chief of Enforcement, and they request a legal review by members of the Attorney General's office. All incoming and completed investigations where we conduct a legal review are reviewed to see if the evidence collected by the Health Quality Investigation Unit actually meets the clear and convincing standard of proof. Why is this? That is the proof standard that is applied by the administrative law judge at the Office of Administrative Hearings in order to make findings that would support legal violations and support ultimately the order. It's all a building block. Currently, that is the physician's right under current law, which is Ettinger, as explained already by Mr. Bone and explained at various points by this board to the legislature. Completed legal investigations stand alone in this review in order to either be independent accusations or to be amended into an existing accusation. All incoming investigations that are completed for the filing of an accusation ultimately are reviewed under the same standard. The requested proposal of the medical board is that one standard be used and that the standard be preponderance of the evidence, as stated already. And this would be to be consistent with other states. Any comparison to other states currently are apples to oranges comparisons. Other states have the preponderance as the reviewing standard.
I think we lost Gloria.
Can you still hear me?
Sorry, Gloria, your audio cut about 5 seconds ago. If you could go back a little bit.
Certainly. The requested proposal of the medical board is that all matters be reviewed under one standard, either the current standard or a preponderance standard for all cases. Currently, this board is being compared to other state boards across the country, and that is an apples to oranges comparison, as other states have the lower burden of proof that their lawyers also review for the same reason I just said. You're looking towards what is going to happen at hearing and not what is collected at the beginning for for investigation. It would be best to have one standard for our Chief of Enforcement to consider as she transmits cases to the Attorney General's office for legal review. Thank you.
Thank you. Okay, I think we have 3 commenters on the line. Okay, let's get...
Yes, our first one is Rosie Arthur's daughter. Your line is open. Ms. Dottie, your line is open for your question.
Okay, let's move on to the next commenter. We'll circle back.
It's from Jen Chaff. Your line is open.
Good afternoon, Jen Chase with the University of California, commenting on SB 815. UC's 6 schools of medicine train approximately 6,000 residents and fellows, or about 45% of the state's physicians in accredited graduate medical education programs. We appreciate the medical board's collaboration to improve the postgraduate training licensing process through SB 815. Like other stakeholders, we are also very concerned about the large amount of PTLs that are set to expire at the end of September. This is impacting hundreds of trainees at the UC and could impact our ability to deliver patient care if this issue is not resolved. We would like to thank the board for their increase in staffing and the recommendations in the staff analysis to address this current backlog. The UC is supportive of moving forward with urgency legislation to extend the expiration date for PTLs, align PTL application dates, and clarify the timing to obtain a PTL. We appreciate the continued collaboration with the medical board, administration, and other stakeholders. Thank you.
And our last one's from Eric Andrus. Your line is open.
Oh, shoot. I wasn't ready for you. Just a sec. Richard Thorpe. Oh, my God. Ever the CMA propagandist. Letting bad doctors practice just to keep the number of doctors up in the state is not in the public safety interest at all. You don't let doctors get away with harm just to keep up the numbers of doctors in California. Are you crazy? I would rather drive out of state than to go to any of the 3 doctors that killed my family members. This is as bad as Ron Lewis saying, well, we can't hang everybody. Imagine if we let criminals off in the courts because we needed their professions in the state. Good God, Richard. Thank you.
Thank you. Can we circle back and see if the first caller is available? Oh, we have 3 more? 2 more? Okay.
It's from Marion Hollingsworth. Your line is open.
Hello, thank you. Can you hear me?
Yes.
Okay, thank you. My name is Marion Hollingsworth, patient safety advocate. I support having a preponderance of evidence so that more doctors will be held accountable for patient harm. Since other states also have this policy, it makes no sense for California to protect doctors over patients. I also urge you to change the policy for interviewing complainants about their cases. I was interviewed over the phone for one of the doctors in my case. This was before my case was then handed over to a different investigator who lied to me about the results of my complaint. I had a second doctor complaint in my father's case, and no investigator ever contacted me. I just got a letter saying he had been sent a quote, educational letter encouraging him to be a better doctor. Within weeks, he went on to overdose a patient after giving him 480 Vicodin pills in a 6-week period. As far as doctors leaving the state, if these issues go through with SB 15, think about it. Doctors are leaving other states because of all the abortion issues, all the abortion laws that have gone through. And this is a tactic that the CMA also uses whenever there is anything that can interfere with what doctors feel they should be able to control about their own practices at the risk of patient safety. So please protect patients with SB 815 the way it is. Thank you.
Thank you. Do we still have one more?
And Rosie Arthur's daughter, your line is open.
Thank you. This is Rosie Arthur's daughter. I'm a patient advocate. We have a problem here. Essentially, you're damned if you do and darned if you don't. If you're a patient and there's rights, no matter what they are, the powers that be, the system will ensure that the opposite happens. The paradox is that the same thing is true for the providers. Every time there is something that is supposed to help them and their patients, the opposite happens. There's been chilling effects that have basically killed off patients that caused the end of grief and sadness and harm by inappropriately charging excessive prescribing of medications. And that's where this preponderance of evidence comes in. If you frame the accusations based on just Part A of the law, 725A, the preponderance would basically convict everybody, especially the patients with intractable pain who were found at the bottom of it. The last section of the law, Part C or D. So what happens is when you read the disciplinary papers, it'll say repeated acts of clearly excessive prescribing, yada, yada, yada. They charge them under A. They neglect to say no physician and surgeon shall be subject to disciplinary action pursuant to this section for treating intractable pain in compliance with Section 2241.5. You never see that. All the ones I've reviewed, they've never done that. So you see a person with intractable pain, not only are they not getting appropriate treatment because maybe they're getting too little medication, not too much, or the wrong medication, but then nothing happens except for a doctor who's willing to treat patients according to the law, finds their license yanked or so severely restricted that they can't help their patients. And now you tell people, well, they can go get another provider. There aren't any providers. So if they're not dead already, they can't get their medication, and changing the guidelines doesn't help. So you need a hybrid of this. So preponderance of evidence if there's only one item, but don't neglect item D and only charge on A when D is the exception. So if there's an exception, then I think you need clear and convincing. So I think you have to apply both at the same time. Look at it not just saying preponderance of evidence on Section A. You have to take in consideration D as well and not charge for something you shouldn't be. Then you wouldn't be turning away other cases that are difficult because you've got so many of these. Charge.
Arthur's daughter, can you please conclude? We're over the 3 minutes.
But it is a bifurcated thing. It is. Sometimes it would be if there was preponderance of evidence on Section D. That's another story.
Ms. Arthur's daughter, please
clear
conclude.
and convincing is just language. Every time they change the language, somebody turns around and says that there's there used to be may, then it had to be shall. Now it has to be must. And it takes years for the language in the regulations to catch up with it. In the meantime, the people who are responsible for the litigation of it, they'll sit back and say, well, we can't do anything because the language is changing. There's always one excuse or another. But
okay, thank you. Are there additional commenters on the line? Okay, we will go ahead and bring it back to the board for discussion. Is there any? We do have a motion to support staff's recommendations, and a second. One thing I wanted to just, I guess, address. Because there's some, I guess I was getting the impression that certain things, we were taking certain things out of this legislation. Unfortunately, this isn't the medical board's legislation. Frankly, I wish it were our legislation because we would have been able to put in exactly what we wanted in the board's sunset report. But notwithstanding the fact that we provided Senator Roth and the legislature with our sunset report and with all of our requests, those requests didn't all make it into the initial bill. Some requests made their way in there in a hybrid or a format that it was not workable for one reason or another under our scheme, because frankly, we're the experts in the way that the Medical Board of California works and the legislature is not. And then, I mean, just using the fee as a perfect example of that, right? Our fee request was $13.50. $1,350, and it's now $1,289 in the legislation. And so we are working hard in partnership with the legislature, with other stakeholders, to advance the board's requests. But you, just like all of you, just like the other various stakeholders that we hear from as well, we are just a stakeholder in this legislative process, and not everything that we ask for is finding its way into this legislation. Preponderance is a good example of that as well. It's not found its way in there in the way that we requested, and we have some deep concerns at the board that if it continues in there, that it's actually going the way that it's currently drafted, that it may actually jeopardize our processes, and that's what we're really trying to prevent against. I also want to make the point that thanks in large part to, recommendations that were made by Mr. Bone and by others a couple of years back, when we really took what I'll characterize as a different approach to the sunset process when we started the conversation by issuing a letter, and that dates back a couple of years now. We got the legislature's attention. So we're talking and working on issues that we were never working on before because of a change in approach. But unfortunately, that still doesn't mean they agree with everything that we have requested. And ultimately, we are a creature of statute. If the legislature doesn't extend our life, then the medical board ceases to exist. We only exist because the legislature authorizes us. So some of these decisions are frankly up to them and not up to us. The part that's up to us is continuing to advance our objectives, continuing to have these important conversations, continuing to let our own, district representatives know how important these things are to all of us as individuals, and having you all do the same as well. And again, continuing to work in partnership with those in the legislature and the other stakeholders. So I just wanted to, sort of level set as to our own role in this process, because if we could have accomplished everything that we wanted to when we issued that sunset report, that was our primary goal, right? And now we're reacting to the legislative, the sausage-making process in real time.
Yeah, and when I brought up, part of the reason I brought up the whole preponderance versus clear and convincing, I think the board overwhelmingly is on the same page for preponderance of the evidence. That's kind of the practical part. The other part might be more of a question for Aaron, is the political part, right? We can ask for this, but I don't know if the votes are there to get what we're asking for. And so it might be a situation of be careful what you wish for, an all or none situation, where we're trying to make a change and we might end up reverting back to where we started without moving an inch forward. And so to me, it's more of a political question on how you want to proceed moving with our recommendation. And it might be more of a question for Aaron than it is maybe for this body on the politics of it. And so I just ask the other board members to be very cautious of our approach and what we ask for, because you might end up right back where you started.
Right. And Aaron, we can kick it over to you for a comment too, but the fact of the matter is we couldn't find an author to put in our request, right? So the request didn't go in the bill to begin with, our preponderance request, right? And so you're right, be careful what you're asking for. Sometimes the approach has to be incremental, but it doesn't mean that that's not our request. It doesn't mean that that's not our collective preference, and it doesn't mean that we're not going to continue to advocate for that. But we are operating in a system where we're not the decision maker here, unfortunately. Okay, Aaron, I don't know if you had any thoughts. I did want, if we could, to have you address the change in the complainant statement, because my understanding was that this was an improvement from the language, but I'm hearing the reaction from those here in the room with us that they don't perceive that to be. So perhaps you could walk us through what's happening.
Both of them. Both issues.
Yeah, both issues are fine. Both the interview and then the statement. Thank you.
I'll try to respond to Mr. Brooks' comment first. I think what I gather from the other executives, the other folks that we engage with when we are doing our work, is making sure that our processes work effectively, meet all the intended desires and objectives, and that we don't have unintended consequences. That's a big factor into why the staff have recommended this all or none approach with respect to preponderance. We're not aware of another state that has the approach that's currently proposed in the bill right now, this bifurcated burden of proof. And so therefore, because of some unintended consequences that might come about, if we do it, hey, some cases are going to be preponderance and others are going to be clear and convincing. I think at the end of the day, we want to make sure that things are, you continue to run very smoothly. So I think that's maybe not a political answer to your comment, Mr. Brooks, but I think that's the basis on where we're coming from with making this recommendation to the board to adopt. With respect to the comments that were heard on the impact statements, so I wanted to clarify. So there's two provisions in the bill right now that speak to that. The first one, and I think it's the primary section, that is section 10 of the bill, and that's adding a brand new section to law, and that's the one that lays out what happens chiefly with these statements, in that once the complaint is referred to the field investigation, the complainant or the patient or their representative will have the opportunity to provide the statement. They get a 60 days notice in order to provide such a statement. And then one of the last portions in that new code section says that those statements shall go to the board or panel of the board for the purposes of adjudicating the case to which that statement pertains. That's kind of the first and the primary thrust, so to speak, with respect to this issue. The amendment in the bill, the amendment in the analysis that the staff are proposing on page 5 is related to the timing, or rather not the timing, it is related to the turning over of that statement to a respondent physician, which speaks to the due process issues and concerns that the board has had since this issue originated some 18 months or so ago. And so the tweak that we're proposing is a technical matter to help make sure that those statements go to the respondent physicians at the time of that expert testimony is exchanged. That's not going to change whether or not the statements make it to a panel. That is secured by section 2220.2 of the bill that I referenced earlier. So I hope that's helpful for the board and for the audience, that the suggested amendment is not going to interfere with whether or not the statements make it to the panel. I hope that's helpful, Madam President.
That is helpful, Aaron. Can you tell us what page of the bill we can find 233, the amendment that staff's recommending to BPC 2334A5?
So it's section 15.
Okay.
Let me try and find it on
page 90.
On the paper version.
It's on page 95. And then 96. Okay.
2234.
No, that doesn't look right.
Stand by.
Okay, in any event, are there other questions on this particular issue?
Yeah, on the printed version of the bill, I have it on page 30.
Oh, I'm sorry, every page is page 95. Okay, at the bottom, it's page 41 at the top, I think.
I go off a soft copy, so I don't have page numbers.
Sorry.
No, it's okay.
Yeah, I'm sorry. It's on page 42, which the pagination is at the top. And so it's that A5 that's being changed. But the real operative section for these complainant impact statements is not that section. That other section is a statement about exchange of various information with respect with experts. Is certain information that is required to be exchanged, but the operative section for complainant impact statements is not changed at all, and it stands, I think, basically as we've requested, or if not expanded from what we had initially requested.
Yeah, there's no staff. I think that's correct. There's no staff recommendation today to make any change to that primary section that we've been talking about.
Okay, and then maybe just addressing what was the other issue, Mr. Brooks, the interview?
The concerns that have been brought up about delaying?
No, more of the concerns, we talked about kind of the 2 points of this process. One, the practical, are we all on board with the language, preponderance of the evidence? And I think for the most part, we are as a board. Then the second part of the question was politically, where are we with the legislature, right? Do we have enough votes at the legislature to get what we're achieving to get? And it's a practical question because if the answer is no, 60% maybe, that might change our approach to our recommendation moving forward. Someone who's been doing this for a while, I understand how the legislature, works in many of these states, and especially in California. And I'm just looking for your expert opinion on where we are with the process with that.
Well, we're getting towards the final stretches, the final few weeks of session, as you know, Mr. Brooks. And so I think the key question that's before the legislature is probably the fees, the fee amount, and the concerns that have been raised by stakeholders with respect to the fee amount. Same stakeholders have raised questions about the burden of proof, and other sections in the bill with respect to felony convictions and how will that be handled. The bill enjoyed a lot of support in the Senate, flew out of the Senate like 31 to 32 aye votes in the Senate, so overwhelming support. The votes have been, well, the one vote that's happened so far in the Assembly has been much closer. So we got just the bare minimum number of votes necessary to get out of the Assembly Business and Professions Committee. With respect to where, and I'm sorry if I'm missing some of the subtleties of your question, with respect to where the burden of proof lands in the vote count going forward, I can't tell you with specificity. I do know that a lot of the stakeholders, again, they're working on the fee. That's a key part of negotiations. But I noticed the burden of proof is also a very high priority for some of them. But again, for us, this is the last opportunity that the board is going to have to speak into the process before the legislature adjourns and some bill goes down to the governor, we hope and expect. And it's very important to, I'll just speak for myself, it's very important to me that what we get right, what gets into the bill is workable and is implementable. And one of the things that we've been discussing and have been hearing from folks is really on the licensing side of things, right? And had that licensing change a couple years ago, and we've been implementing it, but that's really led to some unintended consequences with application volume and timelines to process those. And so trying to avoid other similar types of situations where the outcome isn't what we want because the language is difficult to implement or has unintended consequences. So that's a big guiding point for me with respect to the burden of proof. I hope somewhere in there, Mr. Brooks, that I've answered your question.
You did a great job, Aaron. Thank you.
All right, Dr. Thorpe, I think you've got a question.
I just want to add just a follow up on that, the question about advocacy in the legislature for the burden of proof. Aaron, is it your opinion that the preponderance of evidence, that having everything be preponderance of evidence as opposed to the way the bill is written with it bifurcated, that is going to be an easier sell to the board, to the legislature, than the bifurcation? I think that's what maybe I'm mistaken, but I thought that's what Mr. Brooks was getting at.
Well, the answer to that question is no, by the way. It didn't show up in the first draft of the bill, and we asked for it.
Yeah.
That's my personal opinion.
I would agree with Ms. Lawson, and we've had, if you just look in the public realm, there's been at least 2 public hearings where the burden of proof issue, came up, and I think the first one was in May of 2022 when Ms. Lawson was there, and then as well then this year, during the sunset hearing, and the idea of bifurcation versus all preponderance was discussed, in both of those, and I think Ms. Lawson as well as our other staff that spoke were very clear that we did not understand how bifurcated would work. And how that would play out in practical effect, and that no other states are doing it that way, and therefore we had been urging to go with all preponderance. Now, again, given where we are in the timing of things, we wish to put that back before the board so that the board can make the decision as to whether it should be all preponderance or all clear and convincing, which is our recommendation, or to say that we're okay with the bifurcation.
We do have a motion.
But I would not expect. Sorry, Ms. Lawson, just to finish the thought. I wouldn't. And I pause, so it's okay. I understand why you talked. I would not expect that. Preponderance would necessarily be adopted. We've been having those conversations, which is why I kind of went through the history of some of those.
So we do have a motion and a second to support staff's recommendation. Is there further discussion? Any further questions? All right, shall we vote?
Just clarify the recommendation. The bifurcation?
No. So the recommendations are on page 9, A9 of our report. There are 6 of them, and then he had a couple other requests. But it's the request for language to delay the implementation of the complaint interview requirement until 6 months after the board receives authority to hire new staff positions. And the thought behind that is exactly what we heard about all morning when a new requirement is authorized and then because of the budget timeline, we don't get the staff. It's very difficult to get new programs up and running. The second recommendation is request a technical amendment identified above related to complainant statements. That's the one we just discussed. Third, request that the legislature either adopt preponderance for all disciplinary actions or retain the clear and convincing standard in all current law. Fourth, request technical changes to the language related to the transfer of the RP program to the Board of Psychology. It seems to me that's a non-controversial request. Maintain the following request: update the expert witness and felony conviction language, remove obsolete language related to a 2012 financial audit of the Department of Finance, and then lastly, to request approval of the new licensing proposals that we discussed. in either the board sunset bill or other appropriate legislation. From my perspective, what this is doing is really providing Dr. Hawkins, myself, and Mr. Bone guidance as we continue these conversations we've been having now for many, many months with the legislature and other stakeholders. And I think the staff's recommendation, if I'm correct, Aaron, is that we also be authorized to continue our work and that Dr. Hawkins and I continue to be your representatives for that work, notwithstanding any leadership change that might happen in the next hour.
No, I think it's irrespective of leadership changes.
Exactly, yes.
Yeah, 'cause
Yeah,
you two were.
that's correct. And
right.
You've summed up the motion the suggested motion very well, which I have from my notes that that motion was made by Dr. Helzer and seconded by Mr. Brooks.
Yes, I believe that to be the case. Okay, does anyone want to talk about any of these issues any further? All right, if not, Janelle, will you please call the roll?
Dr. Bullock.
Yes.
Mr. Brooks.
Yes.
Dr. Hawkins.
Yes.
Dr. Helzer.
Yes.
Mr. Watkins.
Yes.
Dr. Mahmood.
Yes.
Dr. Sai.
Yes.
Dr. Thorpe.
Yes.
Madam President Lawson.
Yes. All right, that motion passes. And Mr. Bone, I don't believe we have any other legislation to go through. Is that correct?
That is correct.
And we still have a couple hours. You just want to talk about some other legislation? I'm just kidding.
I'm happy to, Madam President. I'm here for the duration.
All right, I think we are going to now, we're going to move on to agenda item 12. So for any callers on the line who were not with us this morning, we are moving agenda item, agenda item 12, which is officer elections. Up till today, we are concerned that based on how long the meeting goes tomorrow, that we could lose a member who needs to travel in the afternoon, and that we wouldn't have a quorum for the vote. And so that's the reason why we're advancing this item to today. I will say it has been just a tremendous honor and a privilege, and certainly an extraordinarily unique experience for me to serve as the board's president, particularly through the COVID-19 pandemic, through a crisis of misinformation in our society, and then through now 2 sunset processes over the course of the almost 3 years that I've been the board's president. I am grateful for the opportunity to have served all of you as your president and to have served the state of California in this very, very high-profile role. It's been just wonderful and terrific to work with our amazing staff so closely. As a board member for I guess it was almost 4.5 years prior to my service in the board's leadership, you don't have the opportunity to interact with the staff in the same way, right? I mean, and we are really interacting on, especially during these sunset processes, on a daily basis, right? On a variety of really important issues and fielding questions and, strategizing about a whole host of things. And so, like I said at the beginning of my comments, it's just been a tremendous honor and a privilege for me to serve in this role. With all of that being said, I want to nominate Dr. Randy Hawkins to serve as the board's next president.
Second.
All right, Dr. Hawkins, do you accept that nomination? Oh, I guess a second's not required, but members may offer a second. So now we have a second and a third.
I accept.
And Dr. Hawkins accepts. We are going to take comments from anyone in the room that may have them. Public comments. Would anyone like to make public comments about this nomination? All right, is there anyone on the phone that would like to make public comments?
There's one person on the queue.
Okay.
Xavier DeLeon, your line is open.
Okay.
Xavier, if you're on mute, we cannot hear you.
Okay.
He is not responding.
Okay, we'll bring it back to the room. Anybody else want to make any comments? Board members, do you want to make any comments? Do you want to give a speech, Dr. Hawkins?
Madam President, can I say a word real quick?
Please.
It'll be amiss if I don't say this, but on behalf of the staff, we really appreciate your leadership, your support, and when things were down at the staff level, your words encouraged our staff morale to keep at the higher level. Thank you.
Thank you. I appreciate that very much.
Well, briefly, and I'll probably have more to say at the next meeting, where I'll probably chair that meeting. I really want to actually just acknowledge the very, very hard work that Christine has done. No small task, with a number of very challenging environmental issues that we're all aware of. And I look forward to working closely with everybody to provide service in a way that's needed. Thank you.
Thank you, Dr. Hawkins. All right, Ms. Lopez, could we have a roll call vote? Can you please call the roll for us?
Dr. Balat.
Yes.
Mr. Brooks.
Aye.
Dr. Hawkins.
Yes.
Dr. Hauser.
Yes.
Mr. Watkins.
Yes.
Dr. Mahmood.
Yes.
Dr. Sai.
Yes.
Dr. Thorpe.
Yes.
Madam President Lawson.
Yes. Congratulations, Dr. Hawkins.
Thank you very much.
I do want to say one of the things we talked about is that I will finish out chairing this meeting and you will take over at the next meeting, just in the same order as we originally anticipated with the agenda. We do need nominations for board vice president and for secretary. To the extent anyone wishes to make a nomination, raise their hand. Dr. Mahmood?
Nominate TJ Watkins for vice president.
Do you accept the nomination?
I'll accept it if there's a vote.
Are there other nominations?
I'd like to nominate Laura Lubiana, who expressed an interest but was unable to be here because of a business meeting.
Okay, thank you. I do know that Lori was interested as well, although I guess she's not here to accept a nomination, but someone can accept it on her behalf, I suppose. I actually don't know what the process is if we have more than one candidate. Do we vote? I mean, do we vote on the first? I guess we don't vote on the first one. We vote on. I don't know what the process is.
No, it's true. There's a few different options, but one way you could do it is to have each member simply, rather than saying aye or nay, you could simply say the name of the person for which you're voting. So that's one option, and tends to be, I think, the most streamlined.
Okay.
Yeah. Another option would be to, once all the nominations are sort of called and, as you said, possibly accepted by proxy, then you could call for comment and vote on each nomination as you go through that list that everyone's aware of. So that's why I think oftentimes the first method might be more streamlined.
Right. I think that's probably right. I believe that's how we did it. That may have been how we did it the last time there were.
Since there's nothing set in stones for election of officers, there is another office that's up for election. Is that correct?
That's correct. So we have the vice president and the secretary. Lori Lubiano, by the way, is our current secretary.
Right. Exactly.
Yes.
So would it be possible if there's only two candidates running and if there's nobody interested or nominated for secretary, we can vote that the top vote getter become vice and the second place winner gets secretary?
I think that's reasonable.
Right, creative and reasonable.
Any thought?
Although I think we were at three nominations. Well,
we have three nominations?
Not to make it complex. At the end, you said a third person was.
No, Lori Lubiano is the same one that Dr. Hawkins.
Oh, I see. I thought you were referring to someone else.
No. I think you probably should see if anyone wants to be secretary first before you decide the voting method.
Does anyone wish to nominate someone or raise their hand to be the secretary?
I told Dr. Sai I was going to pull him into this too.
Now you guys are just trying to.
I see the coalition. Yes. It's the island. And so sounds like we have a nomination for vice president, a nomination, or two for vice president, one for secretary, correct?
Dr. Sai for secretary?
No, I withdraw. I want everybody to be happy, yeah.
No, when you say, if I say Brian Brooks, then it looks like it's my second choice. But I would, well, it's just a name that jumped out because he's done so much already.
I'm sorry, what, I didn't understand.
I said I nominated, if Dr. Sai withdraws, I would like to nominate Ryan Brooks.
Oh, you want to, oh, I see, now you're nominating Ryan Brooks for secretary, okay.
Only if no
And
one
I'll
else wants
second
it.
that.
Okay, well, so folks, we're going to have to figure out how we're going to make this decision, because we
So
have,
I think the first thing to do, since we have a nomination for two for vice president, let's figure that out. There's only one for secretary.
fair enough.
Two separate votes.
I think,
If that is going to be the rules of the game, I think we should vote for vice president first.
That's what Mr.
And
Brooks
then
is
renominate, right. Oh, okay, I'm sorry. I didn't-
yes, so then if someone is not elected the vice president, then they can also decide
sure.
whether they want to potentially be the secretary. Fair enough.
So, because of the intimacy of this organization, is it possible to do this on a secret ballot?
Sadly, no, but I appreciate the option being brought up. Just per the Open Meeting Act, we can't have the election done
okay.
that way. Short answer.
We all know each other. Anyone who was around for previous elections knows sometimes these things are unusual and uncomfortable and all those things, but that's why we get paid the big bucks.
Yeah, right.
All right, let's do a vote. Let's do a vote on vice president. We have, the vote is going to be either Lubiano or Watkins rather than yes or no. And so please, when your name is called, just indicate your choice.
My apologies on this. I forget if we covered the comment portion for the VP nomination.
I guess that's right. We did not cover the comment portion for the VP. So we'll open that for public comments. Is there anyone in the room? Is there anyone on the line? Okay, we have no public comments. No one else wants to be involved. No.
That's, been doing this for a long time.
All right, okay. So Janelle, will you please call the roll, and then, like I said, either state Lubiano or Watkins.
Dr. Bullock.
Miss Lubiano.
Mr. Brooks. Dr. Hawkins.
Lubiano.
Dr. Hauser.
Miss Lubiano?
Mr. Watkins. Dr. Mahmood.
Mr. Watkins.
Dr. Sai.
Lubiano.
Dr. Thorpe.
Lubiano.
Madam President Lawson.
Lubiano. And Lubiano carries?
Yes.
Okay, thank you. All right, Mr. Watkins, would you like to put your name in for secretary?
Yeah, I nominate Mr. TJ Watkins for secretary.
All right, do we have nominations for secretary? Okay, we have Mr. Brooks. Do we have other nominations? You accept the nomination?
Yes.
All right. By acclamation. You can. Maybe I'll nominate myself for the secretary. No. All right, so public comments on Ryan Brooks for board secretary? Anyone on the line? Okay, so we will bring that vote back to the board and we will vote on that.
Dr. Bullock.
Mr. Brooks? Yes.
Oh, there is a, okay, well.
It's my wife.
Yeah, now we're really going to find out what Mr. Brooks is all about. Here we go. Okay. yeah, all right. All right, let's open it up.
Marion Hollingsworth, your line is open.
Hello, I tried to, can you hear me?
Yes. Hello, Marion, we can hear you. Did you want to comment?
This system isn't working today. This phone system just isn't working. I tried to get on to give my support for Mr. Watkins and could not get in on time, so I'm late. So just, I guess, disregard my comment.
Okay, thank you. All right, is there anyone else on? Great. Okay. Let's vote on board secretary.
Dr. Ballot.
There's one nominee, yes. Mr. Brooks.
Yes.
Mr. Brooks.
Yes.
Dr. Hawkins.
Yes.
Dr. Helzer.
Yes.
Yeah.
Mr. Watkins.
Yes.
Dr. Mahmood.
Yes, Mr. Watkins.
Dr. Sai.
Yes.
Dr. Thorpe.
Yes.
Madam President Lawson.
Yes.
The motion carries.
Thank you. Congratulations to Dr. Hawkins, to Ms. Lubiano, and to Mr. Brooks. And thank you for your willingness to serve in the board leadership, and may the medical board, gods or whatever, treat you all very, very well over the next year or so.
Optimistic.
Yes.
Yeah.
With that, we are, I believe, adjourned for the day. We will be back at 9 a.m. tomorrow morning for what I hope is a great educational opportunity for all of us. We're going to be hearing from experts from Kern County. We're going to be hearing from experts from the state, and we're going to be hearing from one of our former board members who also has a really deep interest in maternal health issues. I hope it's going to be educational for us. I hope we all appreciate that the issue is so big that we're not going to be able to tackle it from every point of view tomorrow, but I hope it's the starting point for a really serious conversation about how the Medical Board of California can do its part and play a role in solving the maternal health crisis here in California and beyond. So we'll see all of you tomorrow morning for that conversation, and looking forward very much to having it and to having all of you here as well to join us for that conversation. So thank you for all the participation today. Thank you again to the Kern County and Bakersfield community for having us here.
Hey, can I make one quick comment?
Please.
I want to thank the advocacy group here. You guys took all your time today. Thank you very much. We learned a lot. The passion is real. Your voices are heard. And I do appreciate the participation. It makes us better as a board.
All right. I guess I'm supposed to say we're recessed until tomorrow morning. Yeah. All right. Not adjourned.